My lord, I want to.
No mentioning for inclusions. I have already taken up.
Upgradation, my lord.
I have taken up all upgradations.
Mention the matter, the client is jumping up for which, my lord, your lordship kindly take up this matter for consideration or order. For consideration, my lord.
I have already taken up all mentionings for upgradations and inclusions.
Mention this matter. When I submitted the academic instruction, I directed me mention on 10.
It cannot be helped because there is no more space in the list. Please come next month.
Thank you.
For consideration.
Consideration matter is not so urgent. Consideration matters are not so urgent.
Setting up petrol pump. For the training for setting up petrol pump for disabled person. Disabled person, they are illegally giving another person. Because he has no land. I made a representation to the authority. And they have started their construction.
Nothing doing now.
My lord,
I cannot help, sir. Please try to understand. Please try to understand. There is a list. There you cannot help. What can be done? Nothing doing.
my lord, if the bank will take possession of the property on the 12th.
Go before the tribunal. Bank will take possession. Go before the tribunal.
Tribunal. I went to tribunal, but tribunal rejected that petition. Against that order, we have come before the court. And
From DRT to DRAT is there. Then the civil revision is there. Why before 226 bench? No explanation, nothing doing.
May I renew my prayer with regard to item number 1719 of today's edition
Upgradations.
for upgradation or your lordship fix any date. It is a matter required to be heard by your lordship because the repudiation of the claim by the insurance company after.
Try to understand.
Lord, I
is
appreciate your
very
lordship's
easy to
predicament, but I have no other option but to
easy
mention the matter.
say that it will take only 1 minute, only 15 minutes. It is very easy to say, but see the list.
Lord, I
pressure.
appreciate your lordship's
It cannot
predicament,
be
but your
done.
lordship kindly accommodate for your lordship kindly fix any date so that I can assure my
cannot
client
fix up a date. There are so many matters already
in the month
fixed.
of March or April so that I can at least
Sorry, sir.
persuade my client that your matter will be taken up in the month of March or April. I cannot wait for an indefinite period, my lord. Your lordship kindly do something, my lord. Otherwise, my lord, I am answerable to my client. It is a repudiation of the claim by the insurance company after occurrence of accidents whereby the
Cannot be done, sir. Please excuse.
Lord,
No.
one staff has died. Another hand of the diver was amputated. The matter is required to be heard.
Do not mention. I cannot help.
Very well, your lordship. My lord, would your lordship kindly fix it in the month of April, my lord? March or April, your lordship kindly fix it.
No.
Lordship, leave may be granted, Lordship.
On
Notice,
prosecution, please hand up.
Lordship,
Yes, madam.
leave may be granted, Lordship. Notice for demolition, Lordship, by the regulated market committee, Lordship. That regulated market committee has been formed under statute, Lordship, West Bengal Agricultural Marketing Produce Regulation Act, Lordship, who has no authority to issue the notice for demolition, Lordship. The land is my land, Lordship, that is adjacent to a hut. That hut is operating by the regulated market
When
committee,
will it
Lordship.
be demolished?
Tomorrow is the date fixed, Lordship. The notice I annex, Lordship, and my land, CS, RS, LR, all are recorded in the name of the petitioners, Lordship.
Very well. Leave tomorrow.
Lordship may be
Serve notice. Leave.
Complete violation of natural justice, my lord.
Sir, I am not including any matters. Not upgrade. No upgradations. Already upgraded matters cannot be heard.
Lordship may
Mention, my lord. My lordship, desire, my lord.
Nothing doing. Don't mention.
My lord, your lordship.
I'll call the list. No.
I mentioned, my lord.
Lordship may Lordship
Only for correction, my lord.
Lordship may Lordship may
My lord, only for correction, my lord.
Lordship
Correction give. Correction. Yes. Correction give.
Correction.
Lordship may
Yes.
Permit me.
Milord, the correction, Milord,
Prosecution, please give.
Milord, the correction, Milord, I have handed over the slip for correction, Milord. Correct.
Month of January.
Whether an American citizen is entitled to file a petition. I have got several judgments, my lord. American citizen is entitled. I have already mentioned matter.
Milord, the correction, Milord,
Kindly see the order.
My lord, American citizen, my lord, having tourist visa, my lord, he has been directed to leave with my lord, he has got 180 days tourist visa, my lord. My lord, he
Yes,
is
item
entitled-
1 in the original side.
Can you let it let it appears to be mentioned, my
Is
lord.
that the way to mention?
My lord,
You put up your hand from behind. No mentioning.
Lordship, non-prosecution. Non-prosecution, Lordship.
Yes.
Only for technical reasons, my lord, I have got it. But I have tried only one line order. It was rejected. But kindly take up tomorrow and I will start forward. Otherwise, my interacting. Since I have one.
Give.
Milord, the correction, Milord, the order for correction that your lordship allowed me. Milord, the
Correction, yes.
correction, Milord, will it appear tomorrow, Milord, to be mentioned, Milord?
Let
The
me
only
see.
thing is,
Let
Milord,
the file has to
paragraph
be
10.
there.
Milord, paragraph 10 of the order records that the fire authority has sent the section 35 notice, but the report is to be filed by the PCB, Milord. Only that correction I am seeking. It will be the fire department, Milord, lordship had directed. It went down as the pollution control board.
Lordship kindly allows, Lordship kindly allows, Lordship kindly non-prosecution.
Non-prosecution.
Non-prosecution, I just indicate one thing. My lord, item 1376, my lord, a lady, a widow, my lord, she is not getting her husband's, my lord, entire proceeds in connection with the public provident fund. The bank, my lord, in spite of, my lord, fulfilling all
You want
formalities.
inclusion?
No, my lord, upgradation. One
Please excuse. Right now, it cannot be done.
As per your order, lordship.
Somebody was mentioning 2018 matter. Does this bench have determination? It has determination. It has. I have to read the list all over again. Right? Yes, item 1.
Your lordship.
My lord, I apologize, my lord, for my behavior, my lord. I apologize, my lord. One contempt.
It's your matter. Item 1.
No. I'm mentioning, my lord.
No mentioning. Item 1. Is anybody
Yeah.
there?
On
Please come.
contempt, my lord.
Yes, item 1.
Item 1.
I am the petitioner.
What is it?
Your lordship, just give me 1 minute for affidavit of service for making notice.
Yes.
Madam, matter
Who is your other side? KMC. There. Is this appearing for the first?
See, my lord, your lordship passed
Oh,
an
you are
order
there.
last occasion. We have, my lord, taken steps, my lord, for demolition, my lord, day-to-day basis. But, my lord, we could not proceed, my lord, as quickly as possible, my lord, because of the steep resistance by the occupants. My lord, we have got a report, my lord, and some photographs to show. Much progress has not been done. It is
What has not been done?
much progress, my lord, demolition work.
Could not be done.
Is, my lord, they are going, my lord, there for demolition, but the steep resistance is there. Well, I'm just giving you.
What is the police doing?
Assistant always.
Even then, you all cannot.
Necessary vacant.
You all cannot do anything.
This is my report. Can you see the report?
না না বললাম তো যেটা আছে সাফিসিয়েন্ট এটা স্কেয়ার হয়ে ভেঙেছি সব
সেটা তো লিখা আছে 6 ডেটে যে ভাঙাটা হয়েছে তো তারপর ভেঙেছে
What does this mean? Fix occupation of occupants?
বল এবার তুই fix।
What does this mean?
বল তিন মানে কি?
There is a microphone over here also.
Although I was asking him.
Yes,
you
what
is
does
the
it
meaning
mean?
of that? The-
And my lord, that is
the-
actually meaning thereby what I actually perceived.
No, your perceivement will not do. What does the authorities say?
Authority fixed, my lord, that is here in the
Fixed
perspective.
occupation?
Fixed occupation in the
of
sense.
the document.
What does
Okay.
it mean?
Just for you know, I was putting that question to my learned junior.
Yes.
That what do you understand? He says that English now. Because like
6-7 days drives were there, police vacated some portions, and thereafter, my lord,
ছবিগুলো দিন তো বলো।
there is also picture. You'll also kindly see the picture.
You know,
also. এই ছবিগুলো দিন।
this is the statement being taken. There's some of the photographs are there.
How many floors?
5 বোধহয়, 5 story, 5 story building.
5-storied building completely unauthorized.
হ্যাঁ, ঠিক আছে, এন্টির প্রপার্টি at best 3 থাকতে পারে।
It's too good.
Huh?
It's too good.
থাক ভাই।
It's a good knowledge.
তিনতলা
So the building is standing, only the head stair, the stair headroom and the roof slab of the 5th floor. The building is there still now.
Is there, but
Now I have to call for the central help.
But I find one the report. I do not know that they say that it was a 6-story old building. They said they could not produce any sanctioned document, my lord, on site.
Listen, the court is not here to listen. It is your authority has given a decision of demolition and you are to progress.
Yes,
So no explanation required from the authority.
কোথায় জায়গার কি করে যাবে? কোথায়
আমি
নিয়ে
বলছি, হ্যাঁ নিয়ে আসছে তো।
এসে নিয়ে আসুক।
ক্লিয়ার চিঠি আছে তো, ওই চিঠি দিয়ে লেখা আছে। যেটা তুমি দিলে একটা কথা।
তার মধ্যে লেখা আছে দেখো।
Where is the photograph of the entire building? It is only a few bricks that you have brought.
Regarding this issue,
But I'm told
Photograph of the building?
যদি
Supreme Court
ও মানে দিয়ে মুক্তা যায় ঠিক আছে নাকি?
Murtaja is one of the same premises shared. Supreme Court এই তো পিটিশনের নাম।
এটা কি দিল?
এই তো অফিসার এসছে তো।
No, one lady may possibly moved to the Supreme Court. They have got a diary number, I find.
What will the diary number do?
Diary number is nothing but
Then
they have approached the court, but that is
সুপ্রিম কোর্টে পিটিশনটা আনতে বললো।
didn't they approach the division bench?
লয়ার লেটার ছিল যেটা দেখি।
vision জায়গা আছে না?
My lord, here is also one letter from the advocate of the Supreme Court regarding the issue, which is actually right.
Any stay order?
No stay order. That is a dated by.
Only the diary number. This 20th.
What will the diary number do?
My lord, this is the premises
Diary
because.
number subject to diary number is given with us nowadays. My lord,
No, it is understood why diary number is given. But diary number does not mean the order is stayed.
Of course.
Then diary number will not do anything.
Here is the letter. Your lordship can see the letter. That there is no stay, admittedly, but.
Why will the court look at the letter of an advocate?
No need
Then,
at all.
No need.
This is not.
It is your decision that the structure is unauthorized. Proceed to demolish. There is nothing in between.
সময় নেই একটু দিব। পুলিশ তো খালি করবে, আগের ব্যাপারটা দেখুন।
কোথায় খালি করবে?
আরে বাবা লিখেছে।
Please come. Now I will direct the central forces.
So theoretically, my lord, chances are given. Let us see, my lord, that whether the upper portions have been, because my lord, the one floor has to be vacated, then we have to take steps. Now the so far as the vacation part is concerned, my lord, still persons are of course, my lord, in occupation of that portion. Therefore, the matter, the demolition work could not be proceeded with. You know, let me, my lord, have a chance, my lord. You know, can in next occasion.
Have a chance
have a
means-
detailed discussion, my lord, to what they are proposing to do, and regarding the vacation part. You know, fix some other date, my lord.
I do not find any reason to adjourn. Because you,
Yes,
what
my lord,
decision
steps
will
are,
you
you know,
take?
say, my lord, day to day, my lord, actions to be taken.
Yes.
We are going there. Subject to, of course, my lord, the finding the portions to be demolished, my lord, is vacated. But if that is not more, that difficulty is there.
Because of the
It has to take
insistence,
their actions, my lord.
because of the insistence of the occupiers,
Of course, my lord, that
police
so,
is
but
unable to do it. You have to take it that the police is unable to do it.
but I am to see, my lord, that
Second page. The PWD
Uh,
give a letter to the executive engineer.
Second page,
Second page of my report, my.
executive engineer, yes, 9th of February,
And report that requested to inform further date of demolition work.
yes. 1, 2, 3, 4, 5, 6, 7 dates are mentioned in page 1. In this 7 date, only progress is the roof slab of the 5th floor and the head stair room. 7 days. The building is 5-storied. You will take 1 year to do it.
ঠিক আছে রিপোর্টে তাই রিপোর্টে যা লেখা আছে রিপোর্টে যা লেখা আছে তাই লিখেছি এটাতে লিখেছি
The police authority, then I can provide the assistance, all assistance.
What were you doing for these 6 days? Your men went over there. You were not able to vacate the premises.
Also, Bolani simultaneously carried on the work.
simultaneously how we are doing that simultaneously okay? You have to take out the parcels from the
Yes.
occupants first, then actions to be taken.
Obviously,
The parcels are still there, I cannot demolish the
the
access
corporation
cannot be
people cannot
taken.
go and just bring them out. They can go to demolish, and you are there to protect the men of the corporation and see that nobody interferes with the process of demolition. Your police is not doing anything, going and standing over there. What will the corporation people do?
The persons to be arrested when in other two premises, your lordship, my lord, has of course, my lord, gave time to us, my lord, but ultimately the police could, my lord, able to vacate the entire premises and the entire building could be demolished.
And
Step
this
by
is,
step.
since the state police is failing, so the central police has to be involved.
যা রিপোর্ট দিয়েছে আমি রিপোর্টের বাইরে কি করে করবো তো ছবি দেখে ছবি দেখে সব বোঝা যায়
Please come.
Sometime.
ছবি দেখলে বোঝা যায়
Peruse the report filed by the executive engineer / building / Borough 3, signed on 6th of February 2024.
Petition participation.
Stop. It appears therefrom that of the 5-storied unauthorized construction, only the stair headroom within bracket major portion and a part of the roof slab over the 5th floor could be demolished. Stop. Demolition work was not possible due to interference of the occupants of the unauthorized construction. Paragraph.
উঠে গেছি নিয়ে আমি
The officer in charge, Narkaldanga Police Station, has forwarded a report signed on 10th February 2025, which mentions that the police affixed notice of vacating and demolition on the outer walls of the unauthorized construction to make the occupants aware of the date of demolition. Stop. The demolition work was carried on 7 days. Stop paragraph. It appears that the unauthorized construction is standing till date. Stuff. The corporation has found the structure to be unauthorized. Stuff. It is the responsibility of the police to ensure that no interference is caused at the time of execution of the work of demolition. Stuff. On the request of the learned advocates representing the corporation and the police, comma, the contempt application stands adjourned till 10th of March 2025. Stop. In the event the unauthorized construction is not pulled down by the said date, comma, then the court will be constrained to deploy central forces for the purpose of execution of the demolition work. It is made clear that the occupants of the unauthorized structure are restrained from interfering with the work of demolition in any manner whatsoever. Photographs ফেরত দিয়ে দিন। petitioner ছিল তো একজন।
না রেখে দিয়েছি রিপোর্টে দেয়নি ওর কাছে কোনো কাগজ রাখেনি বদমাসটা যেটা দিলাম ওটা কোনো কাগজ রাখা হয়নি
for implementation of an order by which the respondents were directed to make over the benefits under the scheme. That after we file the matter, this application, they have complied with it, implemented it and paid us the money. I'll just indicate one aspect of it, not all that is left, is the aspect of interest. Lord, if your lordship sees my lord's last order of 26th of November 2024, paragraph 6 records that the prayer for grant of interest made by the petitioners on account of the delayed payment will be considered by the court on the next day. So I'll just address your lordship only on this issue, my lord, on payment of interest.
When was the payment due?
My lord, in terms of my lord Justice Bhattacharya's order, payments were to be made by December 31st December 2023. Paragraph 55 of that. This they carry to appeal, they lose, then to the Supreme Court special leave petition gets dismissed. Page 36 of the writ petition, if your lordship has a look at.
Yes.
Paragraph 55. Accordingly, so and so are allowed, thereby directing the respondent therein to
Yes.
disperse the sums respectively due under the two schemes in question to the petitioners in each of the writ petitions at the earliest positively within December 31st, 2023.
And when was it paid?
Now, the payment was made to us on 24th of January 2025.
Yes. And what is the payment about?
Now, the payment is for certain benefits under a scheme which I am entitled to, and now this is my right is also crystallized by this order. The amount comes to approximately 40 lakhs. So, delayed payment on interest on this aspect.
Yes.
Lord, this was a grant. This was not a work that he had done, and on that, Lord, there was a delayed payment. This time was extended, Lord, by your lordship, Lord, till the 31st of December 2024. That's the second last paragraph of that page. Can you have a look at it?
That it was December 2023.
24, my lord. Kindly looks to paragraph 4 at page 239.
Which order?
My lord, this
GA1.
GA1.
Application we have filed.
Is directed to make payment to the petitioners by subject to the order passed by the Honorable Supreme Court in the review.
My lord.
No, but
So
then
this-
it was not an extension of time.
My lord, I was directed to make payment of such and such to the petitioners by 31st December 24. And my
Initial
lord,
order is
this
31st
money,
of.
I'll tell you, Lordship, my lord, this money is a grant from the central government. I am only a nodal agency. What happened was, my lord, in 2021, when the money came to me, it went back to the central government. I have not made any delay, my lord, in whatsoever. It's the central government, my lord, who gives me money. I only, my lord, disburse it to them. Nothing beyond that. The central government did not want to give them money because of a certain, my lord, things which happened. Then they came to court. Courts wanted us to pay, my lord. We paid.
You paid means the
Central government paid.
central government
Central government paid, not me.
pays through you.
Through me. Just that I am only a nodal agency, my lord, who only disburses money. Nothing. I have got no role to
The
play.
last payment which was made to the
Central
petitioner,
government.
when did you receive the grant?
In 2021, then we wrote, my lord, several letters are there that we said that the courts have asked us to make payment. Please grant us money. The money came. The moment the money came, we, my lord, paid it to them.
When did the money come to you?
And I had to file an affidavit to that effect.
It won't be required. This argument, Mr. Chatterjee was only there. This argument was made before my Lord Justice
Absolutely.
Bhattacharya, saying, please implead the government. The central government is necessary party. It has been held. This point has been thrashed out that you are the body. You have floated the scheme. It is your obligation to pay. Therefore, you will pay. His source of fund, so far as I am concerned, is not relevant for me. Decree, let us say decree is against the son is to pay. Son has gotten it from the father is not relevant for me. When
My lord,
son has delayed the payment,
it's a
whether son will
grant.
pay me interest or not,
Not something, my lord,
that's
which
the
is-
different
it's
aspect
a
that we can
grant.
argue. But whether his source of fund is not relevant.
There's no question of, my lord, he having some extra benefits because there is a delay of payment. The problem is, my lord, there have been extensions from other honorable courts, my lord. I can put that all on record. I have got
Extension for what?
for this payment only. This payment. Have a look at it. Lord, what the problem is that I don't have my money of my own. The government gives me, my lord, I only disburse it to them. And if they claim a right over me, my lord, even here, they are in my respectful submission, my lord, it would probably get into unjust enrichment as well.
One,
Definitely, this is a grant which is given for
This is
buying
not a-
machineries.
well, this-
So he cannot make a profit out of that. Look, I'm sorry.
Did you lose anything
Nothing.
because of delayed payment of this grant to you?
my lord, firstly, it's my entitlement. My lord, what Mr. Chatterjee now seeks to do is actually go behind Justice Bhattacharya's order, nature of claim, what is the nature of the grant. I am not on that. Court has directed payment of money by a certain date. Party has defaulted. What is the
No
nature?
time is extended over
No,
here.
that's my point. No, this is not a case of time
Secure.
extension. Implementation of the order gets extended because of some application that they filed before the Supreme Court. Well, this application is for implementation of an order which is already
No,
passed.
just tell me whether you are entitled to receive an interest on account of this delayed payment of the
Well, I'll tell
grant,
you,
as you say.
kindly comes back to page 36, paragraph 55.
Yes.
Accordingly, one such are allowed, writ petitions allowed, thereby directing the respondent therein to disburse the sums respectively due under the two schemes in question to the petitioners in each of the writ petitions at the earliest positively within December 31st, 2023. So my right to receive the money, irrespective of the nature of the money, the right to receive the sum crystallizes as on December 31st, 2023. Irrespective of the nature of grant, his source of fund, a court has held I'm entitled to this money. This money he pays in January 2025. On this, he is liable to pay me interest because it's a court order which directs him to make the payment. And there he is defaulted. Additionally, the bunch of orders that Mr. Chatterjee hands over, he has put this money into fixed deposit.
Has he shown
Yes, he
that
had.
the
He
authority
had only
has,
handed it. I was waiting for Mr. Chatterjee to hand it over. Kindly have a look at this 12th August. Arika copy ache? Kindly have a look at this.
is it the same order?
Shortcut kuch. Hey, 2 minute action point.
276.
Kindly have a look at this 12th August. Ache. For me, I love messaging. 12th August 2024. This is for your information. So and so Justice Shampad Sarkar, wherein express direction was given to the National Jute Board to maintain a sum of 40 lakhs in any of the accounts. Will give me a minute.
Yeah, this is a problem.
In compliance to respond. This is a problem for Mr. Chatterjee. If he doesn't know what will I do. This is his junior only handed over his client.
No,
Amount of 1 crore 91 lakhs means fixed deposit of so and so, out of which an amount of 40 lakhs is directed by this court shall be duly maintained, kindly turns over, my lord. Oh, এত জোরে করছে আমি নিজেকেই শুনতে পাচ্ছি, একটু আস্তে আস্তে বল না বাবা। Kindly turns over fixed
Yes.
deposit.
This
That's
is amount 1 crore 91
Yes.
is inclusive of your amount also 40
Yes,
lakh.
that's what he says. By means of Kamak Street at Kolkata, out of which an amount of rupees 40 lakhs is directed. So 40 is covered by 191, kindly turns over. This was, and my Lord Justice Bhattacharya directed the payment to be made by 31st December 23. This fixed deposit made on 8th of January 24. He
Yes.
earns interest at 6.85% per annum. This he can't deny me. This has nothing to do with the nature and the claim of the money. This is my entitlement which put
Take
into
in-
this,
take
this money he has
instruction.
to make over
Take
to me.
instruction.
Instruction, my lord. Here what happens is, Justice Sharka's order came, your lordship just saw. We were asked to, my lord, keep this in as a security, my lord. This amount of money, which is 40 lakhs, which is this as a security, my lord, of the money which was due to him. Nothing more than that. The money
No,
didn't
but then
come,
1 crore 91 is inclusive of
was there,
40.
my lord, earlier as well. All the funds which the I
If it
had.
was there and you earned interest, why not
No,
pay
no,
to
it
the
was not
petitioner?
his money. This was a different set of money altogether. Not the money, my lord, which we had got from the central government for his dues. No, no.
You cannot segregate money in that manner. Money doesn't have a separate color. It's
doesn't-
your money. It's her.
He
His
says
money.
in compliance of an order of court that this 40 lakhs is made a FD. In
You-
order, in terms
Please
of an
take
order of
instruction.
court,
Please
he
come.
says 40 lakhs is not. This 6.85 he has to make over to me.
It
It's
has
not
been
beyond
brought to the
before.
notice of the court that the payment
Lord, your lordship needs me to take instructions, my lord.
in terms of the order passed by the court, order and a judgment passed by the court on 16th of January 2023 has been disbursed only in January 2025. Stop. The petitioner claims interest on account of the delayed payment. Stop. It has been brought to the notice of the court that the National Jude Board has invested the sum in question in fixed deposit and a fixed deposit with the Bank of Baroda.
Correct.
And has earned 6.84% interest per annum. Stop. Paragraph. The learned counsel representing National Jude Board seeks time to take instruction. Stop. When? Next Monday?
Next one.
List on 17th.
Great.
Yes, my lord, I am for the petition, and I pray for the time of 2 weeks because the advocate on record has suddenly fallen sick, and all
Who
the
has fallen sick?
advocate on record is sick, and hence all the documents, including affidavit services, are lying with her, and including the original documents. And so, my lord, I cannot.
What is
take
the
out
matter
the case.
about?
Regarding the assessment of stamp duty made by the collector,
All right.
after impounding of the document, what should be the stamp duty valuation of the property?
Kindly
Let it
keep
be
me,
adjourned since there is a request
15 days out.
on the request made by the learned advocate representing the petitioner. List the matter on 3rd of March.
Most of them.
My lord, I appear in this matter, I appear for the private respondent. Can it be fixed weeks later? On that week, my lord, I have some difficulty personally with regard to my father's illness.
10th of March.
10th of March. Okay. I want to leave this.
My lord, I am for
My
the
lord, I
petitioner.
appear on behalf of the state respondent, my lord.
On the last
For the
question,
respondent number 1.
my lord
We have the
directed
direction
the state
upon
to
us to
produce a
obtain instruction,
document.
my lord. Just now this instruction has come up, my lord. This is the old record, my lord, of 2019 when the municipality forwarded us the letter, my lord. Kindly see, my lord, I have folded the page, my lord. The 3rd page of my instruction, my lord. My lord, we have issued a letter to the municipality to refurnish us the document, my lord. Just today in the morning, my lord, it has happened, my lord. I received this instruction on my WhatsApp and I just took the printout, my lord. Kindly grant us some breathable time, my lord. But that memo has been issued on January 2019, my lord.
Immediately thereafter, I filed the
Today
RTA
is
application.
10th of February 2025.
My lord.
Today is 10th February.
My lord.
This letter that you have folded is dated 10th of February. How and when was this letter prepared?
It has been forwarded to me on my WhatsApp just now, my lord. They
It is
said,
prepared now. It is dated 10th. It could not have been forwarded to you earlier.
my lord, they have issued this letter today, my lord. By it, my lord, kindly see what is the content of the letter, my lord. They have asked municipality to furnish by in the course of the day. My lord, give me some breathable time, my lord. We will get it, my lord, and we will produce this before your ladyship, my lord.
The municipality will not hand over the copy.
My lord, will I be permitted to mention, my lord, the document, my lord, the municipality submitted before the, my lord, chief information officer that the document is not lying with the municipality. But my lord, on the similar issue, my lord, one writ petition was filed in the year 2019, my lord. Similar prayer, my lord. My lord, from that record, my lord, I have got, my lord, that inquiry report, my lord, from the earlier writ petition.
My lord, the memo is, my lord, 10th January 2019.
Is there any memo number?
Yes, there is a memo number. That is, my lord, memo number 1087/D.
Yes.
Have it.
Dated 11th January 2019.
Yes, my lord,
Yes,
this is
given
the memo.
My lord,
This is the
memo
memo.
is here, my lord.
This is the memo.
Same, my lord, issue, my lord, same prayer.
No.
Earlier on
That
the
was my lord
schedule,
WPA 7300 of
No,
2009.
that was,
Filed by whom?
by the present petitioner, my lord.
my lord, that is part of the writ petition.
My lord.
Part of the writ petition, it has already mentioned that writ petition was for expeditious disposal of my complaint. Now, when the authority has disposed my complaint, that matter already got infructuous. This matter I have.
Is it still pending?
Yes.
Yes, that is old matter. That is still pending. That
Which
was
year? 2019.
2019. That was, my lord, for direction upon the authority for expeditious disposal of my Section 18 application. Now the Section 18 application has been disposed of. Therefore, that matter has already got infructuous. Here I have challenged independently the.
You want this?
Yes, I
You
want
got
this,
it?
I have handed over to him, my lord.
Yes,
Kindly
yes.
see the
Please come.
number 2, my lord.
Yes, this is same memo.
Everything
Learned advocate representing the municipality
sir, fully मेरे ने night up पे गेला.
has produced a copy of the memo number 1087/DDM/GBM/2019 dated 11th of January 2019, signed by the chairman Damna municipality. A photocopy of the letter. You can say. The same has been handed over to the learned advocate representing the petitioner in court today. Stop. Paragraph. In the writ petition, the petitioner prayed for supply of the aforesaid memo. Stop. Since the same has been supplied to the petitioner in court today, comma, nothing remains to be decided in the instant writ petition. The writ petition stands disposed of.
Grateful.
My lord, I am for the petitions.
In this matter, I am advocate on record for the petitioner.
What is the matter about?
Lordship, this is, my lord, against the vacuum, my lord, fulfilling the vacancy in the West Bengal State Consumer Disputes Redressal Commission, my lord, for a long duration. The matters were being adjourned, and my lord, recently probably the court number, there is an appointment, my lord, there was an appointment in court number 1, Honorable President's bench. That was, my lord, single judge was present over there, and due to not
Now is it functional?
Yes,
Lordship.
yes.
How
Lordship,
many
may-
benches are there?
No, his prayer kindly, my lord, may I
Three benches are there, my lord. Court number 1 is of
you are
precedence.
concerned with, Lordship, may I respectfully invite your Lordship the prayer clause of the writ petition, my lord. At page 13, my learned friend prays for a mandamas, directing the respondents herein to take immediate necessary steps for appointing the honorable members in court 1 of the respondent number 3. So, my lord, here I have this is the instruction answer to the, they have already been, Lordship. Court 1 is functioning.
Please come.
Lordship, may I make a short submission? My lord, may I draw your lordship's kind attention to page,
What do you want? Your court 1 is functional now.
lordship. But
Then-
my lord, may I draw your lordship's kind attention to page, para,
No, no,
prayer
what is your,
once, prayer OF once.
yes? To
Lordship, the
conduct
time is
hearing,
still 4:30.
yes.
After 2 p.m., my lord, no matter is, the bench doesn't take any matter, my lord, after 2 p.m. any day.
What can be done with
My lord,
these?
this is,
We have a
my lord,
monitoring.
kindly see the rules, my lord, I have annexed.
No, I am aware.
Fixed.
I'm aware of it.
Everywhere.
I am
my lord,
aware
the
of it.
same problem in Lordship. They are also in the WAF tribunal also, we don't find any session after
After
recess.
recess.
Yes.
So very sorry to say all this on Lordship.
My lord,
Lord,
kindly see, my lord,
Please
Lordship,
come.
there is a monitoring regulation my learned friend is telling about. That is procedure. Lordship, there is a monitoring body of this. May I respectfully invite your Lordship to this regulation? This is also regulation of 2020, which you have annexed. That is, apart from that, there is another regulation.
Lordship,
Where the National Commission or state, they have the monitoring capacity, power to monitor the functioning.
Lordship, kindly see
And
page
it's the
41 once.
The instant writ petition
Lordship, kindly see page 41
has
once.
been filed.
My lord, at the bottom, my lord, kindly see the hearing hours are there. This is
Yes,
2020.
yes, no one is
already handed.
disputing.
Lordship,
The writ petition was filed seeking for issuance of a writ of mandamus, directing appointment of the members in courtroom number 1 of the Consumer Disputes Redressal Commission.
State.
West Bengal State Consumer Disputes Redressal Commission. Stop paragraph. Learned counsel representing the state of West Bengal has produced before this court a write-up from the Special Secretary to the Government of West Bengal, Department of Consumer Affairs, signed on 10th December 2025. No, 10th. What is the date? The communication that you handed over, what is the date?
10th to 10 to 20, 10 to 2020.
February.
Yeah, today I have
Today,
received
All right, 10th of
in the
February.
morning.
Lordship, may I have a copy?
It's a 3-line letter. I'll write over here.
Order.
All right.
Achha, dated 10th of February 2025, mentioning that at present bench number 1 of the forum is functional and is taking up matters on regular basis. Stop. Bench number 1 currently has the required quorum. Stop paragraph. Learned advocate representing the petitioner points out that according to the Consumer Protection, bracket open, Consumer Commission Procedure, bracket close, Regulations 2020. The hearing hours of the Commission is from 10:30 a.m. to 1 p.m. and from 2 p.m. to 4:30 p.m. Stuff. It has been submitted that the bench hardly functions after 2 p.m. Stop paragraph. Learned counsel representing the state respondents has brought to the attention of the court the same regulation which mentions about the hearing hours. Stop paragraph. It is expected that the commission shall function strictly in accordance with the regulations laid down and will abide by the hearing hours as mentioned in the said regulation. It petition disposed of.
Right.
My lord, I am appearing for the respondent. My senior is online.
But yes, but the petitioner is not there. Petitioner, I don't think, but they have fixed the matter. To do, your lordship, the last occasion, your lordship, please to direct that the matter will appear on 10th. Your lordship, kindly see the order sheet.
Yes, I can see the order.
It's not the I am for the respondent, but this is a matter, tender matter. I am for the MSTC.
MSTC.
MSTC respondent number 2.
Yes.
Well,
Has the tender, the work order been issued?
But yes, not tender, it was a process for these materials tendered by the MSTC for sale. But the MSTC issued the sale order. But MSTC's function is to conduct the e-auction. Now, the petitioner case is this, but petitioner went to the process authority, the goods are not there. But they are claiming for refund. But my submission is this under section 230 of the Indian Contract Act. The disclosed principle is process authority. Therefore, MSTC has no role to play on the prison, but our function is nothing. After issuance of the highest bidder's order, but
is anybody there for Prasar Bharati? Prasar Bharati is a party over here.
But they are not appearing, the petitioner is also not appearing.
None appears for the petitioner. At the time of call, no accommodation sought. The learned counsel representing Union of India is present.
MSTC, not 2.
Achha, respondent number 2, MSTC. Stop, dismiss for default.
I'm grateful to your lordship.
কি হয়েছিল এটা? হয়নি?
My lord, I am for the respondent number 2. I'm free.
Well, I'm the petitioner.
What is the matter?
Yes. Well, petitioner.
You are for
I
the
need to be the
respondent.
company.
2 and 3, National NBCC. Yes.
Sir,
petitioner is a private limited company,
All right.
namely Mrs. Translink System Private Limited, providing external electrical works and fittings. A tender was awarded to the aforesaid company in the year of 2015 in favor of the petitioner. Tender for electrical works and fittings at Victoria Memorial Hall, where Honorable Prime Minister will inaugurate the galleries on 9th January 2020. The petitioner have done that work completely and satisfactorily. And for that, a bank guarantee has already been released in favor of petitioner. Everything has done, but after 8 years, NBCC Limited raised objection. The entire work is done perfectly. In spite of that, he demanded the figure 586.06 lakhs for within the 7 days. Madam, kindly see the page 4.
Page?
Para number 5.
Page?
Page 4.
Show me the document.
The annexure P2.
What is
The
the page
tender-
number?
tender-
Page
ten-
number.
Page number.
Annexure
47. Where is the
47, yes.
impugned communication asking you to repay the money?
47.
2015.
Page number 47. Annexure P2.
It is dated 2015.
12th February 2015.
Show me the document which is troubling you now.
Yes. Madam, it is the letter raised on 1st October 2024, annexure P8. Page number 75. And page number 76, annexure P9. Letter dated 8/11/2024, NBCC Limited sent to the petitioner that with reference to the above, it is informed you that you have failed the verified to work done by you through third-party independent agency appointed by VMH authority, resulting which the work done by you amounting to rupees 586.06 lakhs have been declared as unidentified by the third party.
Yes. What is the error with this letter?
Error is electrical fittings of the entire work in VMH was, just a minute, madam.
What is the instruction?
My instruction is we are disputing their facts, my lord. We will file an objection, an affidavit in opposition, my lord, because the entire work was not completed. We had asked them for rectification of the lighting system. They have not done. We had to go with the third party to make the rectification, my lord.
Madam, inauguration
My lord,
has already been done.
So what? Inauguration done means your work is over?
That is insecurity feeling over there.
they had not completed.
Prime Minister has come.
Prime Minister coming, does it mean that you have done your work properly? It is not so.
The bank guarantee has already been released in favor of petitioner.
Thereafter, certain disputes might have cropped up.
We have communicated those disputes as well. They have not rectified. And now they're asking for.
There was opportunity granted to you for rectification of the defects. There are communications.
Madam, just
February 10,
page number 10,
2020.
Your Lordship. Point
Page number
23.
72. Page number 72, I see a communication of 2020
Yes.
that the lighting system installed is not working properly. What did you do?
This letter dated on February 10, 2020.
Yes, what did you do thereafter? Did you do anything? Then why will the writ court entertain? Even in 2024, you have been directed to verify. You have been directed to Yes, the third party was requested to verify the work done. You have not done anything.
Your lordship, kindly have a look on page number 10, point number 23.
Come up with a written report. Please come. The petitioner is aggrieved by a communication made by NBCC within bracket India, bracketed by Limited, on November 8th, 2024. Directing the petitioner to deposit a sum of rupees 586.06 lakh as the petitioner failed to verify the work done through third party independent agency. Stop paragraph. Learned advocate representing NBCC is directed to come up with a report. How soon can you come?
My lord, kindly.
Why?
You have to ask from the Delhi office, my lord.
Delhi office work was done over here.
All the reports, my lord. Kindly, my lord.
अच्छा की बोललाम? With a report. Report, stop. Such report shall be prepared and circulated by 28th of February 2025. List the matter on 10th March 2025. Exception, if any, may be filed prior to the adjourned date.
In this matter, I am appearing on behalf of respondent number 3 and 8.
Affidavit of service, my lord. And my lord, there is a supplementary affidavit I have come up with, my lord, on behalf of the petitioner to incorporate certain subsequent facts that has developed, my lord, after filing of this writ petition and after the passing of your lordship's last order on 13th of January 2025, my lord. If your lordship, I have already served a copy of the supplementary affidavit upon the respondents, my lord. If your lordship permits me, my lord, to file it before your lordship, my lord.
What happened on the day of opening the bid?
My lord, on 13th it was supposed to open. It did not open, my lord. It opened on 30th of January, my lord.
All right.
My lord, those documents I have annexed in my supplementary affidavit.
All right.
Permit me, my lord.
Yes.
Grateful, my lord.
And what is the fate?
My lord, the fate is, my lord, petitioner was already rejected, my lord.
You were rejected.
Yes, my lord.
Credential not as per the requirement
Yes,
of the executive rank.
Now it turns out, my lord, the L1 bidder
Yes.
265 times less. Is
Yes.
265 times the more, my lord, than the bid of the petitioner. My lord. That also have incorporated in, my lord, the supplement.
That is a different thing, right?
My lord.
You were only concerned in this writ petition
My lord.
with the with your rejection on the ground.
Yes, my lord.
Credential not as per the requirement of the executive rank.
My
We are restricting the
My lord.
writ petition to this only.
My lord. My lord.
Further
My
cause of action,
My
further writ petition, we'll see it. Everything cannot be done in one writ petition, right?
My lord.
Now you tell me, what is the error in this remark that your credential does not match the requirement?
My lord, my learned senior will address.
Yes.
Lordship, I will lordship's attention in page 23, my lord.
You are subject to lordship's consent. May I submit one?
Who are you?
Because Lord, there are 4 candidates who have been declared L1. There are 27 works.
All right.
All are under challenge. There are 4 persons who have been allotted field. Lord, L1, we are the L1 bidder. Now, Lord, we are about to get the work order. Unless and until we are imputed as a party respondent bidding. If any.
Your implement will expand the scope. Let me see if I feel there is any error, then I'll include you. The court will not pass any order in this writ petition which will affect your rights. Who are you?
My lord, I am appearing on behalf of respondent number 3 and 8, that is
3 and 8.
West Bengal Agri Industries Corporation and Executive Engineer West Bengal Agri.
All right.
My lord, only thing, my lord, first of all, the application.
Let the petitioner place his case first. Thereafter, I'll hear you. Yes.
Lordship, in page 23, my lord.
23, yes.
Eligibility criteria participant bidders.
Mm.
It says in one work similar nature in the magnitude of 40% of the work done. Second, my lord, in the semi, 2 similar works, each on minimum value of 30% of the work. All these things and works has to be done by authority of the state, central government, state government, central government undertaking, statutory bodies. In this situation, my lord, I am just referring my credential in this respect, my lord. Please allow me to submit. In the same work, my lord, that is the high mast of the electrification, pole and certain electrification is done. This sorts of work is done is basically 2 levels. At the Gram Panchayat level, at the block level, that is done by the Panchayat Samiti. In these cases, agriculture marketing has been allowed to execute on the same Gram Panchayat. I am giving some example, my lord. I have executed the work and payment certificate has been issued by, it is in page 50, my lord. Majhira Gram Panchayat, that is within the same Gajal block, my lord. Then another work, my lord, in Salaidanga Gram Panchayat, that is also same block under Gajal block where this sort of work is being done. In Raniganj 2 Gram Panchayat, that is where I have done my work. And all these works, in my first case, my lord, I have done the work of 3,45,848. In the Salaidanga Gram Raniganj 2 Gram Panchayat, the work order is the 2,46,379.
All right, let me hear. Let me hear. What is the reason for his rejection?
My lord, kindly see the page 23 about that.
23, yes.
That no credential. 23 2 clause 2.
Yes, no credential.
Criteria for participation in the tender. My lord, no credential.
Yes, no credential will be considered.
Considered as valid. Unless it is supported by payment certificate, work order, price schedule, or BOQ of work and completion certificate issued by the competent authority, not below the rank of executive engineer. The completion certificate should indicate the value of the work, but he did not file any certificate from the executive engineer.
All right.
Not below the rank of executive engineer.
So no certificate was there.
Enclosed. Beside that one, she did not attend the previous meeting, which was held on 16/12/24.
Attending the pre-bid meeting is not something compulsory, right? If she has not attended, not attended.
Compulsory, because only if there is any query that what is to be done regarding the NIT, then it will be clarified.
It answered on the same day.
And besides that, my lord, kindly came to page.
Petition also can be done. There is a provision.
Kindly came to page 30, my lord. 35, my lord. Kindly 26 and 27, my lord. If there are any queries regarding tender terms, POQ or any other issues, it should be communicated on or before pre-bid meeting. After pre-bid meeting, no queries will be entertained. Next, my lord, 27. In case of any objection regarding qualifying an agency, that should be lodged to the executive engineer WBIC Limited within 2 days from the date of publication of the list of qualified agencies, and beyond that time schedule, no objection shall be entertained. She did not comply in.
Yes, I have followed.
My lord, firstly, my lord, in that in their schedule, the date of their uploading of the technically bid, that has not been mentioned. This means I don't know when the bid will be selected and finally.
That means you are not interested with the tender.
No, my lord, I'm coming. The moment it was published, then the next date I came before the lordship.
No, your,
I'm coming to that point, lord.
your coming before the court is not important. Your reporting to the authority is far more important.
Because, my lord, the 2 working days were the holidays. By this time,
Working days, holidays, the court is holiday. They are
my lord,
over there.
I'm just raising one point, my lord. My tender is a process wherein all the participants equally placed should be made open so that each and one can participate.
I am not
I'm just giving you one example, my lord.
no
As
example.
far as
Please come.
my lord, one submission, my lord. One submission, my lord. I am just citing the case law, my lord, decided by this coordinate bench, my lord, the same issue, 100% same issue, my lord. I'm just giving just one example, my lord. Just one line, my lord. May I kindly submit, my lord, one line, my lord. I'll not take more than 2 minutes, my lord.
Rejection.
My lord, may I kindly be allowed, my lord?
On the ground that her credential is not as per the requirement of the executive rank.
My lord, one line indulgence, my lord. There lies the case, my lord.
Learned advocate representing the tender issuing authority refers to the provisions of the notice inviting tender, which mentions that the eligibility criteria for participation of the tender records that no credential will be considered as valid unless it is supported by payment certificate, work order, price schedule or caps BOQ of work and completion certificate issued by the competent authority not below the rank of executive engineer. It has been submitted that the petitioner did not submit any documents from any authority as mentioned in the eligibility criteria. It has further been brought to the notice of the court that according to clause 26 of the notice inviting tender, if there is any query regarding the tender terms, BOQs, Q apostrophe S, or any other issue, it should be communicated on or before the pre-bid meeting. After pre-bid meeting, no queries will be entertained. It has been submitted that the petitioner did not participate in the pre-bid meeting. Paragraph. Clause 27 of the NIT has been placed, which mentions that in case of any objection regarding qualifying an agency, the same should be lodged before the executive engineer within 2 days from the date of publication of the list of qualified agencies. And no objection will be entertained beyond the said time schedule. It appears that instead of drawing the attention of the concerned agency, the petitioner has rushed to this court. The petitioner ought to have availed the relief as already mentioned in the notice inviting tender. Paragraph. The court is not inclined to exercise jurisdiction in this matter. The writ petition fails and is hereby dismissed. Service is taken on record, but supplementary affidavit is not required.
I'm grateful, my lord.
Question for the petitioner.
Yes.
The petition is before your lordship by the Malda Apollo Nursing Home, represented by the owner. Well, this is the matter that where a authority is trying to play the role in a two manners. One is under Shastro Sati scheme, another is under BNSS procedure, my lord. And in the meantime, this is third round of litigation, my lord. We are coming before your lordship. My lord, may I hand up one list of dates I have prepared, my lord, for your lordship kind consideration. My lord, what happened? The petitioner yet to get 11,68,000 of rupees under the Shastro Shati scheme. When we have made the application before the state government, after that, 14th November 2022, Additional District Magistrate Malda given one notice that I have to close down my nursing home and sealed it and raise one allegation amount that I have to pay as a point of fine.
As fine?
As a fine, which is beyond his jurisdiction. Because Shastro Shati scheme, I can show your lordship, I shall show that only panelment and depanelment, this much he can do, because the reason is this: under the Clinical Establishment Act, the COMH has given the power, because he is the expertised. Those criteria which was given, that has to be detected by the COMH on the basis of one complaint, either by the patient's party or any other party. Not suo motu they cannot take. But I have given 25 points by the Additional District Magistrate Malda. And on that basis, my lord, I have given one show cause by the CMOH. And in reply to that, I have given reply. And in the meantime, my lord, what happened? That CMOH Malda given license to renew my further business of the nursing home. There is a dual role. The day when given the show cause, and prior to that, CMH already given me that you can continue with the business. I am providing you the license. But after that, what happened? I have given one reply, but that reply is remained still pending. No response has been given, because show cause reply has to be given, whether they are going to terminate it or not, but it has not been done. And my lord, kindly, I have given the all annexures where I have taken the point, the reply. My lord, being dissatisfied with this action, I have filed one writ application. And by order dated 21st November 2022, one interim order was passed. And the authority moved before the division bench. And there, my lord, what happened? That interim order turned down, and that order which has been passed, it has been upheld. But there is a direction given. The applications which are, because my lord, there are two applications pending. What I have challenged, another, the amount which was due, that I have also challenged, and that is the two petition was pending. Division bench given me the direction that these two petition has to be heard together. After that, my lord, what happened? Again, 27th February 2024, ADM Malda, I have request for renewal of license. Why? Division bench given one direction that it has to be heard together. Unless until it is not been heard, you cannot take decision, because sub judice before the single bench. Prior to that, my lord, same authority, the additional CMOH, given a recommendation that yes, this nursing home can continue with the further license.
What is the problem now?
The problem is this, my lord, that additional district magistrate, those reply are yet to be given in several representations and show cause. Now the order impugned passed under the BNSS. Lordship, kindly come to the last annexure. Last annexure. There is a page 153. Initially, they tried to stop me in that manner. When I could not, they failed to do so. Under the BN, what they have done, at the first instant, it has been closed down. And my last line, my lord, I have given the hearing opportunity by today. Lordship,
10th of February,
Lordship, yes.
12 noon.
Because within 72 hours, but today is the date, my lord. My lord, I am submitting before your lordship that if I am lacking of any service which has been given under the scheme, either you have to follow under the scheme which has been violated, or Clinical Establishment Act, the CM which has been empowered, you can give show cause and you have to give reply to that.
Please show me your license given
My-
by CMOH.
Yes, sir.
No license after 3rd November 2023.
Prior to that, I shall show your lordship.
No, but then right now, are you running without a license?
Absolutely.
No, I'm coming.
Please show me.
He's
your
right. He's
license.
right. I'm without license. I'm running. Why, my lord? Yes. Why? Because division bench given single bench of this one of the court given the permission and direction to them within 2 months. You have to clarify whether license can be renewed or not. Till such time, I have not been stopped. Till such time, I could not get any new patients. Those patients were there. I have to treat them. But what happened last Friday, when I could not approach before your lordship and move this matter, it was on over phone call. It has been emphasized given that doctors should not enter into the premises. It has to be locked down, and they have locked down. And my patients are still there, and some of those patients has been driven out. My lord, I am submitting that if I am not been permitted from that 2022, so in the year 2024, all on a sudden, they are taking the plea, I have to seal it. Prior to that, 3 occasions they passed, seal it. They did not. Because matters were sub judice before your lordship's court.
Show me the order directing the authority to take a decision.
I am grateful, your lordship.
Page 142 possibly, my lord.
My lord, no. It is that page starts with page 120.
124, I can see one.
Yes. 124, it starts. The relevant portion is at page 128, 129. My lord, may I read your lordship?
Which paragraph?
Paragraph 9. 9
It
onwards.
appears from the notice that the challan were issued to be deposited. Application for renewal license is pending. So, September 24, the court takes note of the fact that your renewal application is pending disposal. Question raised shall be raised and decide the matter on the basis of the record.
Para 11, my lord will kindly take note of.
Validity has expired and prior the petitions were assessed of no entry market to allow the nursing to continue.
And my lord, this court given me the liberty to approach before the redressal forum. That I have approached, and that is also pending. And within 2 months, they have to take decision. No decision taken.
The issue of renewal shall be decided within 2 months from the date of communication. So September 24, when did you communicate?
My lord, I have
Sometime
communicated
immediately
it on
thereafter.
25th, 9, 2024. And my lord, when I have sent the contempt notice against them, all on a sudden, they issue this notice, my lord. Because they are under the contempt, because they are avoiding the court's order. And this issue perhaps not been arise, you have not claimed the Sastoshati amount.
124,
My lord.
the authority is yet to take a decision on your...
Today, if I am not go there, I cannot represent, it will be written that it will be absolute. Man, asking, without giving an opportunity of how they pass the order predetermined?
No, your client must be there.
Yes, client was there, but
was there, is there. It's just 12.
They are there, my lord.
10th of February, 12 o'clock. So the hearing
My lord,
must
only
be
one
continued now.
submission, my lord, may I advance to your lordship that on Friday to this Monday, no doctors has been allowed to visit my patients, those who are admitted.
You tell me, where from are you getting this right to continue the business?
My lord, my lord, that could have been sealed down earlier, my lord.
No, that is different. The fact that
No, I am not taking any new admission. Onwards, when the matter was pending after division bench, single bench, just now lordship seen, I have not taken any new admission.
Where is the division bench's order?
My lord, division bench order, just prior to that point.
Page 107, my lord.
I'm grateful to my learned friend. My lord, relevant page is, my lord, 109 onwards.
No, 109.
108, it was
31st August 23 order set aside. What is that order?
That order of the single bench, that interim order to stay operation of the passed by the additional district magistrate.
Is 25th of September 2024, 124 page, it is annexed. Is this the final order? This the writ
No,
petition
no order has been passed. That is the reason I have come before your lordship. Let me say I have to stop.
Acha,
I cannot take decision further. But one after another proceedings they are trying to take recourse, my lord. That troubles me a lot, my lord. And my lord, the penalty amount which has been imposed, that has to be decided by the redressal forum, where I have made application pursuant to the direction of the court. That is pending. And my lord, they are not empowered to impose any fine, impose any penalty. Only say panelment or DA impanelment. And in the meantime, they have to open another medical center. Rastoshathi scheme to the. My lord, lordship's convenience, may I hand up the Shastroshati scheme, my lord?
No, we are
Grateful,
not
lordship,
doing
sir.
all these things.
I'm grateful, lordship.
Okay.
And another thing is, my lord, lordship is asking me that how I can run this business, my lord.
Yes.
My lord, kindly give them how the AC additional CMO is given me the recommendation to them that let it be start, my lord, during these proceedings. I have annexed the document, my lord.
Which page?
Lordship, I'm grateful. Yes, lordship. My lord, one moment, my lord. কোথায় রে এটা পেজটা কোথায় এটা ফ্রেশ চেকটা করলি ওটা বার করো না টাইপ কপিটা দাও
টাইপ কপিটা এই যে টাইপ কপিটা এটা
my lord this is the copy which I have annexed and this is a fresh copy my lord perhaps that was not legible এই তো তোমার annex করা আছে
legible মানে কি বুঝছো
দাও কপিটা দাও তাহলে পড়তে সুবিধা হবে পেজটা বলতে পারলে না এখন পেজটা Yes, my lord, page 106 of that application. It's the inspection report on the basis of the additional CMO which given me the recommendation that it can be opened.
This is 28th of November 2023. Visited
During
the
pendency
nursing
of the
home
applications,
for inquiry regarding renewal of the CC.
my lord.
All relevant papers and documents have been checked and verified and found in order.
My lord.
So license can be given for renewal
lord.
for 1 year.
My lord.
Right? Even if assuming it is for a year, that means December 24, November 24, it is over.
My lord.
But from November 23, you say that it was not formally extended.
No.
It was not formally
But
extended.
prior to that, my lord, prior to this recommendation, lordship kindly come to page annexure P2.
license to cancel
2020, this is annexure P3, page 52, my lord. This is the recommendation by the CMOH prior to issue of show cause that 2022 it has been done. I can continue it up to 2023. After that same office giving me the recommendation, it can be continued. But ADM is talking only on that point. No, you have to pay the fine. Those he has no right to impose this fine.
Listen, paying fine
Man, per 52.
is something different.
Page 50.
From paying the fine is different from running the nursing
My
home.
lord.
Paying
No, my
fine,
lord, subject to kind sanction. If I deposit the fine, subject to kind sanction, I can run the business. That is their point.
no, I do not know what is their point.
Then, my lord, some basis of the calculation, some reasons, my lord, that reason has yet to be provided to my client. How can I understand?
It is there.
My lord,
Lord, he
kindly
has-
visualize the situation.
Let me understand once.
May I? But it's really unfortunate that we have to, the district magistrate has to invoke the provisions of public nuisance. But that is the impugned order to stop this nursing home. What was the initial order? My lord will find at page 50. My lord will kindly come to page 50.
But will we go through all this today itself, because there is a hearing going on?
My lord, as on date, my lord will kindly come to page 50 for once. I'll take
50.
50.
50. There is the order First, sorry, bhai. Sorry.
5-0.
Well, this is the order
Yes.
imposing penalty. It is passed on 14th November 2022. My lord, will kindly see the grievances that the inspection team has found. One, no GNM staff was found during the visit. 2, my lord, RMO was not present at 9 wards. 3, many expired injections were found in the ICU. 4, OT was assisted by people having no medical qualification. 5, ICU technicians not found present. 6, one patient found in the labor room whose baby died. She was referred to gynecologist but not attended by the gynecologist. 7, my lord, the dead body of the baby was kept on a tray outside the OT.
No, tell me who is giving this? The ADM. General.
ADM is the adjudicating authority under the Clinical Establishment Act, my lord.
Adjudicating authority.
Adjudicating authority.
Adjudicate what?
My lord, adjudicate in case of violation of the CE Act.
Who reported to you about the violation?
There were several complaints. My lord, kindly give me 1 minute.
তুমি একটু বসো, প্লিজ হ্যাভ এ সিট।
কি হচ্ছিল যে স্বাস্থ্যসাথীতে কাজ হচ্ছে সেটা ঠিকঠাক হচ্ছে না, এরকম একটা কমপ্লেইন।
Lord, we have received complaint stating that the nursing home is not running with proper infrastructure and not rendering proper services under the Shastro-Shati scheme. My lord, will kindly see the
under the scheme.
Yes.
Listen, try to understand one thing. Had the scheme not been there, even then, with a certificate of enlistment, the nursing home could have run. It is not necessary that the scheme benefit has to be given by the nursing home.
My lord, will kindly segregate. My lord, he is clubbing everything together. My lord, will kindly segregate. Allow me to segregate the things. This order is not in challenge before your lordship.
No.
This
That's
is
page 50.
Page 50 is not. She has not challenged. So, my lord will not go into the not go into the who was the under which scheme this order is passed. Under the CE Act, Clinical Establishment Act, he is supposed to run the nursing homes with certain parameters. Now, my lord will kindly see the deficiencies.
No, these deficiencies are such that you want to bias the court with these are the difficult deficiencies. The nursing home will not run.
I will not.
There is a recommendation which has been showed. How did the CMOH recommend?
My lord will appreciate as on date. Even if I take, as has fallen from your lordship, my lord, even if I take the recommendation to be sacrosanct, this is a file noting, my lord, there is no
formal recommendation, renewal.
There is no averment as to where he has found this noting. My lord, I do not know of its authenticity, and even if I, my lord, agree that the AC homage has, my lord, recommended, the CMOH is the competent authority. Now, my lord, he has refused the extension of the CE license as on date. A nursing home.
Where is the refusal?
It is there. My lord will kindly come.
No, he says it is pending.
No, it's not pending, Lord. It is.
Where is the refusal? Please show.
My lord will kindly give.
They have to show the communication to us also.
Yes, certainly.
I'm grateful, your lordship.
It is there. It is there.
কারণ না ভাই, আপলোড করে দিলে তার কমিউনিকেশন হলো। সাবজুডিস ম্যাটার আপলোড কি করে করে?
সিওকে জানানো হয়েছে পরে।
Rejected. Page 96. Well, kindly see page 96.
Page 96
of this, my lord.
What is this?
My lord, this is the documents I have, my lord, today to satisfy your lordship.
But then does the petitioner have?
I have to inquire and come back with that instruction. My lord, see the date of it.
Copy দেবে আমাকে?
Page number
96, my lord.
96.
Very small, my lord, written on the top, my lord.
Yes, yes.
The resolution is full copy.
Points of imposing penalty. Where
Page
is
96, my lord, will, may I hand up?
application? Renewal
Relevant
application is,
document, my lord.
this is the reference that is chief medical officer rejected. You have to apply fresh with such and such. This is 6th of February 25.
No, it is rejected. As on date, it is not there.
The writ petition was filed on the 5th, and immediately on the 6th you go and reject
My
it.
lord, my lord.
And without
my lord,
supplying a copy.
Lord, he did not have a CE license.
No, he admits that his application for renewal is pending. That
Pursuant
is
to the
his
court's order.
case.
My lord, kindly give me one moment. Yes, ma'am. This is 6th February 2025. 6th February, Canada? This is on 6th February 2025. Lord, as we are gathering, my lord, there is not one, but several, my lord, discrepancies. I will only see page 96 of.
Tell the petitioner that these are the discrepancies. This is what has been
We'll
recorded.
communicate.
I have not been heard, my lord. I have not been heard and passed the orders to seal.
He has extensively.
This is the exception.
My lord,
This is the
what I have handed to your lordship, my lord, has documents to show that he has extensively participated in the hearing.
In the hearing.
When?
Extensively, my lord.
Give me the
Give me the dates.
dates when he was heard.
I will kindly give me a moment.
The last order which was
My lord,
passed
page
by
17, my lord will kindly come. Of my, my lord, note.
compilation. Yes, page 124 in the writ petition is the order of Justice Shorkar, which is dated 25th of September 2024. 2 months time given to you for consideration. Give the petitioner, show me something that you complied with the order passed by the court. Nothing more.
My lord will note in that order itself, the court, my lord, paragraph 11, had said, my lord, he's not entitled. Paragraph 11, my lord, as the period of validity of the license has expired, and prior to such expiry, the petitioners were asked to stop admitting patients. So at that stage, the court is not granting any interim order in favor of
No, the court is aware.
My lord.
And I have seen this. You show me that you have acted in terms of the direction passed by the court on 25th of September. Show me.
May I take 1 minute of your what is not there, I must not attempt to develop.
Yes.
I must not.
I understand it is not there. Otherwise, it would have been there in my table by now.
True.
So it is not there.
It is not there.
You are to take steps in terms of the order which has been passed by the court. There is nothing in between. And the 4th of February 2025, how could this be issued when you have not complied with the direction passed in page 120?
I am grateful, your lordship.
Please come.
And my lord, may I
petition
make
is
one
agreed.
submission? My lord, may I make one submission? Just my lord, the first annexure, page 50, the order impugned, that earlier order, there is no suspension of my license. Shastho Shati admission has been stopped.
Whatever. We are not going back.
The
petitioner is aggrieved by the notice.
My lord, may I draw my lord's attention to one fact? My lord, as on date, there is no patient in the hospital.
Yes, he is told that you locked it.
Forcefully taken out.
Yes, that he is told.
Well,
the aggrieved by the notice issued under 152 within bracket 1 within bracket small b, B and SS for conditional closure of the Malda Apollo Nursing Home dated 4th of February 2025 by the Additional District Magistrate within bracket General, Malda. Stop. Apart from several other discrepancies, what has been brought to the notice of the court is that the nursing home is running without a valid certificate of enlistment. Under the West Bengal Clinical Establishment (bracket open) Registration, Regulation and Transparency (bracket close) Act 2017. Stop paragraph. From the documents annexed to the writ petition, it appears that the petitioner filed an earlier writ petition, being WPA 24032 of 2024, which stood disposed of by the court on 25th September 2024. Directing the Chief Medical Officer of Health, Malda, to take a decision with regard to the prayer of the petitioner seeking renewal of the license within a period of 2 months from the date of communication of the order, upon granting adequate opportunity of hearing to the petitioners. Stop. It appears that the direction passed by the court has not been complied with till date.
No, it is complied with. The order is passed, my lord, rejecting.
It is with you, not communicated.
It has, my lord,
not
is,
to the knowledge.
All on a sudden,
true, it is
Not
not.
to the knowledge.
after filing the writ
Very well.
petition.
Your submission I'll record. ঠিক আছে? Next. It has been submitted that the respondent authority has, not the respondent authority, the district magistrate has forcefully locked the nursing home by removing the patients from there on Friday, 7th February 2025. Friday, 7th February 2025, and has also restrained the doctors from attending the nursing home. Paragraph. Prayer has been made to, it has been submitted that the aforesaid closure notice has been issued without granting any opportunity of hearing to the petitioner. Stop. It has been brought to the notice of the court that the additional CMOH recommended the recommended renewal of the certificate of enlistment on 28th of November 2023. But despite such recommendation, the renewal was not allowed. Stop paragraph. Prayer has been made to set aside the closure notice. Stop paragraph. Learned counsel representing the state respondents relies upon a compilation of documents in support of the submission that the prayer for renewal of the certificate of enlistment of the petitioner stood rejected by an order dated 6th of February 2025.
I have a document to show it was emailed on 6th also.
Stop. The aforesaid order of rejection was communicated to the petitioner via electronic mail. Paragraph. It has been submitted that there are several discrepancies on the part of the petitioner in running the nursing home, and it is sheer nuisance that the nursing home is functioning without following the provision of law. Stop. Next.
I will kindly take note,
Of
take note of page 96, which is a fire license. Look, this is a fake document.
of
It's
the
a
writ
fake-
petition,
Page 96. Below.
it has been submitted that the fire license relied upon by the petitioner is a fake document.
At page 96.
And they have
Next.
taken decision on this
Annexed at
document.
page 96 of the writ petition. ঠিক আছে, তারপর? On a query from the court as to whether the decision with regard to the renewal of the certificate of enlistment was taken upon affording opportunity of hearing to the petitioner as directed by the court on 25th of September 2024, there is no positive response from the end of the respondent authority. Stop. Paragraph. It appears that the prayer of the petitioner seeking renewal of the certificate of enlistment is pending consideration for a considerable period of time. Stop. Since the nursing home is providing health service to the patients, the authority ought to have acted within the prescribed time period. Stop. The authority, for reasons best known to them, kept the application of the petitioner pending for years together. Stop. Even after the court directs the authority to consider his prayer, to consider the prayer for renewal within a specified time period upon affording opportunity to the petitioner, the same has not been complied with. Stop. The Chief Medical Officer of Health unilaterally takes a decision on the petitioner's application without affording the petitioner any opportunity of hearing and rejects the said application by an order dated 6th February 2025, immediately after the writ petition was filed before this court on 5th of February 2025. Stop. The 5th of February 2025, after obtaining leave from the court. Stop. Paragraph. It appears that the it appears that the action of the authority raises doubt in the mind of the court with regard to the impartiality in which the authority took a decision. Stop. Paragraph. In view of the above, the impugned closure notice dated 4th of February 2025 is directed in view of the above, the respondent authority are restrained from giving any effect and or further effect to the closure notice dated 4th of February 2025 till a decision is taken by the Chief Medical Officer of Health with regard to the renewal of the license of the petitioner. Stop. Next. A decision shall be taken by the CMOH at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Stop. An opportunity of hearing shall be given to the petitioner to produce documents in support of the prayer for renewal. Stop. Paragraph.
By
It is, however, made clear that the petitioner will not be allowed to run the nursing home till a formal decision is taken by the Chief Medical Officer of Health in this regard.
we are grateful. Let the matter keep pending, my lord. Or else, my lord, they will never take back. They can have to file contempt, my lord.
You
Kindly.
have to file if this is the
And my lord,
procedure
the
you have to
redressal
file.
forum where I have made the application pursuant to the direction of the court, that is to be heard. My lord
He
was
has
given.
separate cause of action.
No. This is
Redressal
annexed.
forum.
My lord, Justice Shampar Sarkar was pleased to pass the liberty that I have to file one grievances before the redressal. That is the 130, my lord.
One grievance regarding what?
All these matters that has been pending also. To clarify my position, that is pending, my lord.
Page
130, my lord.
Well, this again, my lord.
No. My learned friend perhaps now troubling your lordship to make him a different way. They have represented in the court, my lord.
Page 130, your application. Grievance, that is different.
Yes, that is redressal for that liberty given, my lord. File come to 128. Can you come to page 1? Wait.
128, yes.
Hey, এটা কথা সম্পর্ক সরকার madam. My lord, kindly come to page 127, paragraph 7.
There is not even the prayer.
Yes. No,
not even the prayer in the petition.
All these are pending. Which one I mean?
Grievance for redressal of the grievances, the decision of the ADM.
This is not even
This
prayed
is
in the repression. my lord.
That have
regarding Shasto Shati.
My lord, they are clubbing together. That is the problem.
He is clubbing together.
And 1 minute, my lord. Redressal committee is the ultimate authority who will take decision.
For what? Certificate of enlistment, the redressal committee doesn't have any role to play.
Because my lord, I have been stopped by the Shastro Shati admission, not by the license, by the ADM. Subsequently, CMH reply is pending. Then I have given the liberty to approach before the redressal forum, my lord. Everything is pending, my lord.
We kindly appreciate. This is not even prayed in the petition.
But what else I can pray?
The respondent authority shall also take steps.
Well, this has no connection to the stopping of the nursing home. This will create.
Direction passed by the court on 25th of September 2024 in WPA 24032 of 2024 at paragraph number 7.
Next plea will be
liberty to approach, which you have approached for redressal up to the decision of the such and such.
Application.
The prayer before the State Grievance Redressal Committee is pending decision till date. Disposed.
Yes. May I take back the compilation?
Absolutely.
Or may I give it to your lordship?
May I get a copy of that document, single page?
I do not know.
No. That copy handed over to your lordship. That now no patient is there, my lord. Well, it will also helpful for me.
He has taken a photograph of that.
Yes, but I'm grateful, your lordship.
Electronic communication has been sent, he says.
No, he says, I can show your lordship, no communication yet been done. That's why I sent my junior to take a decision.
I'll also show.
I have recorded his submission.
Yes,
if it is not there.
If I played any tricks, then I've been thrown out.
Yes.
This is a personal grudge, my lord. I have to pay different manner.
Yes.
I'm grateful, your lordship.
In item number 4, lordship, I beg to appear on behalf of the petitioner, lordship.
I beg to appear
My
for the
prayer will be in
vocational council, who will be the West Bengal State Vocational Council.
Vocational Council.
For the respondent number 9.
You kindly see the prayer, lordship.
I am for the petitioner, lordship. There is my prayer will be in threefold, lordship. That the complaint made by the petitioner before the concerned authority, there are two respondents, lordship. The answering respondent. That one is, lordship, the Pharmacy Council of India, and another is, lordship, NCT. Now, the respondent number 9 is a member of a trust who running a college, two colleges, lordship, in the same building, lordship. Now, when I have lodged the complaint, Lordship will find from page number 31. I draws the attention of the Chief Administrative Officer, West Bengal State Council of Teachers and Vocational Education and Skill Development Department, and another is the President of the Pharmacy Council of India, who are the affiliating body to run a college for D-Pharma courses. I draws their attention by this letter of communication or dated 23rd of May 2024. When this letter has been communicated, what we have find, Lordship, that in a same building, they are running two separate colleges. So far the rules and regulation is concerned, Lordship, this person is get the affiliation from to run a B.Ed college in a building, Lordship, and subsequently he applied to run a college for the course of D-Pharma, diploma in pharmacy, Lordship. He also shows the same building and got the affiliation. Now, Lordship, being the member of the trust who have been driven out from the trust earlier occasion, Lordship, there are several criminal cases pending. I lodged the complaint before the concerned authority to take draws their attention to this effect, Lordship, whether they can run the two separate colleges in a same building or not. Subsequently, Lordship, I got threatened, and then after I lodged a complaint before the concerned police station. Police do not take any steps, Lordship. Subsequently, I filed this writ application under the police in action heading, Lordship. This matter earlier taken up by the Honorable Justice Tirthankar Ghosh when his Lordship was fined that the matter is relating to the affiliation. Whether the affiliation will stand or not, that is the question, Lordship. Subsequently, the matter has
But
been
then
assigned.
you say it is police in action.
We have filed under the heading of police in action, and that has been released. I made a complaint, Lordship will find.
This is to be placed before Justice.
Kindly come.
Who are you for?
I am appearing for state respondent. Kindly come to pray.
Who are you for?
I am for the vocational council. Respondent.
Vocational council.
Kindly come to the prayer portion.
Please wait.
Yes, respondent is my lord at 7.
West Bengal State Council of Technical and Vocational Education and Skill Development.
Yes.
Now, so far the determination is
For the state, you are for the respondent number 9, the private respondent. You are running the college.
This is absolutely an internal dispute of the college, Malad, on an earlier occasion, Malad, your lordships, Malad, this is the observation, your lordship can see. And Malad, he is the man, Malad, who is thrown out from the trust by way of a civil court order, Malad, he knows it. He was a party there, he contested that. Now, Malad, to disturb the Malad, college administration, Malad, he is lodging one after another complaint. Even on the basis of this complaint, Malad, an inspection was done. Your lordship kindly sees the report of the Pharmacy Council of India. Malad, this is the report.
Final report submitted.
This is the report. 2 times Malad, inspection has been done. This is the report. The Pharmacy Council of India, Malad, in the month of October, even Malad, the members of Pharmacy Council of India, Malad, visited the college. On his purpose is only to disturb the management by any way or other. Once he lost the complaint, they stopped my affiliation because he is ousted from the entire management by way of a civil court order. Now this is the way he is trying to camouflage the entire situation. He is trying to disturb the management, and so far this petition is concerned. Your lordship kindly sees the prayer. Sees the prayer. What is there and what is he submitting now? His purpose is very much clear. To disturb the management.
One thing may I just submit. Although there is no prayer against the vocational council, but yet, my lord, after receiving
even on his complaint, my lord, this inspection was, and this is the second inspection by the pharmacy.
Yes, council.
But my lord, although my lord, there is no prayer against me, but finding this is as his complaint, we have, my lord, carried out an inspection, find that some of the there's a discrepancies in the running of the colleges. So we have issued show cause notice, and ultimately that we have one de-affiliated that college.
Give. Please come.
Now, my allegation is that not purpose, Lordship.
No, that
he is
is
running the 2 colleges in a same building, Lordship.
My lord, this is the first one is the show cause. Then
The petitioner is aggrieved by the manner in which
renewal of affiliation may not be allowed.
Arjo Bharat.
It is not deaffiliated.
Shikha
Renewal of affiliation has not been allowed.
is being run.
May I take Lordship's kind leave, Lordship?
No.
My Lordship, he's here, Lordship.
No, you are doing the matter and you will take leave. Then who's going to, if anything is required? Acha. কি বললাম? Is being ठीक ताई a complaint was lodged before several authorities, including National Council for Teacher Education and the authorities of the Baba Saheb Ambedkar Education University. And also before the police. Stop paragraph. Learned Council representing the West Bengal State Council of Technical and Vocational Education and Skill Development এখানে আছে, হ্যাঁ,
Shall not be revoked.
relies upon a communication dated 3rd July 2024 by the Chief Administrative Officer addressed to the principal/head of the institution that a show cause was directed to explain with regard to the anomalies observed during the inspection of the institution and to explain as to why the council shall not revoke the affiliation for violation of the academic norms of the Pharmacy Council of India. Stop paragraph. It has been
As well as my lord that of the West Bengal State Council of Technical and Vocational Education.
it has been
And your lordship kindly sees my report after
brought
this
to the
Pharmacy
notice of the
Council
court
India
that
conducted inspection.
by a communication dated 10th January 2025, the renewal of affiliation for the 2-year diploma in the pharmacy course in the academic session 2024-2025 has been rejected. Stop paragraph. As it appears that the West Bengal State Council of Technical and Vocational Education and Skill Development has already taken a decision not to renew the affiliation of the course, pharmacy course, because of the anomalies detected at the time of inspection. Accordingly, the relief sought for by the petitioner appears to have been allowed. Stop. The writ petition accordingly stands disposed of.
The Bengal board has never conducted any inspection. This is by Pharmacy Council
Careful, your lordship.
on the basis of this application.
ফেরত দিয়ে দিন,
Of October, your lordship.
এটা ফেরত দিয়ে দিন।
Careful, your lordship.
For the petitioner, madam, this is the airport authorities. This that matter, airport authority issue the order, whether it's a final order or not.
Whether
My
it
lord,
is a final order or not.
Appear for the respondent, your lordship, 327,
By-
Airport Authority of India.
by the evidence says it's not a final, it's not a final order.
I have submitted my report, your lordship, on the last occasion.
Can you allow me?
Yes,
At page 4 of the opposition, my lord.
right.
At paragraph, sorry, at page 2, paragraph 4.
Page 2, paragraph 4.
Page 2, paragraph 4 of every opposition. The same
Merely
notice.
an advisory.
Yes, he said that this is my lord. So my lord, input this order is at page 200. My lord, so can you at page 200 for a moment? My lord.
Yes.
This order is under challenge before lordship. They say,
Yes.
my lord, if yours can, they say no, it is not a final order. It is a the form. Yours can you see the rules for a moment?
What is the use?
No,
Take
there
it
are-
as an
there are-
advisory
there's
and then
There's another part. I am coming to the other part. My language is very clear, my lord. Other part is that, my lord. I see the rules for just a minute, at
Page?
at page 164.
Yes.
Just a minute. Sorry, sorry, my.
No, sorry, 168, sorry, my lord.
Yes.
But here, my lord, what he has said, my lord, it comes under Rule 3. You got it, my lord? At page
Yes.
168. What he has said, my lord, is in the form of the show cause or advisory at Rule 3. So Rule 4 is to be complied with, my lord. Next, after 3, what the advisory means, it is under the campus of the Rule 3, my lord. Now, Rule 4 is to be complied with, then question of final order. It is okay, my lord, he's correct, one is not a final order. Now, by this time, the other thing has happened. If you also kindly for a moment, kindly come to page, my lord, first, my lord, kindly 169, my lord. My lord, they have issued a no objection for regarding permission of top elevation in 2016. Can you see 57.85 meter? Now, my lord, on the basis we have made the construction. Now, my lord, also there is a survey. Can you come to page 205, my lord? They said,
yes,
they said location is not correct. Now they say after 5 years, location, so it should be 51 meter. This is, my lord, they said at page 204 in place of 57. Now, my lord, on the basis thereof, they have now passed another order. This is at page 213.
Yes.
They say it should be 51 meter. My learned friend says this is appeal, you go to appeal. I said it is not appeal, it's not appealable order. Why I'm saying, my lord? They said without giving an opportunity hearing, I think they have reduced it. Now, if you also can come to page 82 for a moment. The rules.
Yes.
These are relevant rules. So can you come to that definition? Who's the designated officer? Can you see? Means the officer of Airport Authority of India responsible for processing and issuing no objections that we have specified Appendix M of Schedule 7. Can you come to page 127? The authority name is given. Page 127. My lord, in our case, the number 2, Regional Executive Director, AI Eastern Region is the designated authority. My lord, who is the respondent of 7 hearing? Now, my lord, can you come to that rules at page 83? At page 83.
Yes.
Processing of no objection certificate cases. Processing of no objection cases in respect of civil kind of designated officer available. Now, T is very important, my lord. A panel of chartered engineers or surveyors may be assigned by the airport authorities to carry out physical verification. This is, I have both the survey, I have discussed my location. They say their survey has done it. Next, my lord, can see 10, my lord. The designated officer specified name shall be responsible to issue the no objection certificate in respect of civil and shall coordinate with the respective local municipal granting approval construction of building or structures. So designated officer is responsible to issue no objection certificate.
Why are you showing all these things?
I'm coming. Why, madam? The order was passed by the other authority. I'm coming. My can you see 12 is 11 is the appellate authorities are there. My lord, suppose when if an order was passed, even no objection was issued, appraised, I'm agreed by this, I can prefer the appeal. Here, my lord, it was issued in 2016. Now they have revised it without giving an opportunity hearing. And secondly, order was passed by another different authority. Can you come to page 13? So you know, just remit back into the S7 to consider it first. Can you come to 2017?
Very well. Please come.
So the issue, and sorry, I said, sorry. Can you 2010 for a moment? Can you take into consideration 2010? Can you
2010.
Sorry, 210. Sorry,
210.
Sorry,
Yes.
this is an order of the appellate in the same area. Applicant is given 68 meters, same area. I see, our also in the.
Very well.
Yes.
কি বলে? The
There's no
the
7 is the-
petitioner
Lordship, just
is
one
aggrieved.
submission. The 213, the NOC which has been given, there is a provision of appeal against that, which I have provided in my report, Your Lordship.
Yes.
The
So
appellate
the
authority.
respondent number 7.
No, Your Lordship.
This is the other appellate authority.
There is another appellate authority.
But then for him, it was issued earlier. The revision took place
Lordship,
without.
there was a fresh application
This is
made by him,
No, this is
pursuant to which this NOC has
This is
been given.
renewal, not the this is
Not a
revised.
fresh one.
Your
That is
page
the
213.
It's of the year 2016.
Yes, Your Lordship.
7 is the authority.
How could you revise it? You reduce the height, and in the meantime, the petitioner has raised the construction.
Lordship, insofar as
This
this
is
NOC at page 213 is concerned,
Yes.
if Your Lordship might kindly come to this.
No, the authority has not given this one.
This is the NOC, Your Lordship, for a different plot. The site
Same.
coordinates are completely different.
No, same plot. My lord, kindly see.
According to you, the location is different, but the petitioner says it's the same thing.
Same.
It
Kindly,
has got only one construction.
Your Lordship, at page 200,
kindly see 169. Same location. 169, 200, same.
the NOC has been at page 201.
Respondent number 9, respondent number 7
7 is my lord.
is the regional,
Director, that my lord, at page 127.
page 127,
Regional Executive Director.
regional executive director,
Yes. He's the authority. He will consider it again.
designated officer,
Code number 7.
Yes. AI Eastern Region, Calgary Airport. Page 127.
processing of no objection certificates.
He can only revise, he can pass the order.
Initial no objection was given by this authority only,
Yes.
and it has been revised.
Yes. By the other authority. Without give opportunity.
Lordship,
He,
at page
my
200,
kindly
they know-
send back to him. He will, I'm not. My hotel is ready. Everything is ready. I can't start it. NKD has not allowed me because of this. Oh.
Yes.
The report, Your Lordship, at the NOC at page 200, that has been signed by the Deputy General Manager Operations
He's not the authority.
for the airport authority, for the airport director. And Your Lordship, the one at page 213 that my learned friend has just relied upon, that Your Lordship has.
Can you see the general manager, not the authority?
General Manager, Airport Authority of
He's not the authority. So you want to remit back, there's no problem. Can you remit back to the 7 to consider it? He's not the authority.
213 is the no objection certificate for the height clearance.
Lordship. This is
He's
of
the-
20th August 2024.
20th of August 2024, and it is signed by
The general manager.
213 is by the general manager.
Yes. No,
Where
that's
is
page
it?
217.
217, where is his signature?
First one, a negative designated officer can see.
Lordship, the designated officer is the General Manager.
He's not the designated
Where
officer.
from he gets to know that he is the designated officer? There are 2 other persons also
Lordship, that has been
I don't know.
prepared
by the committee.
the Joint General Manager, and it has been verified by the Deputy General Manager.
None of them is a designated officer. So 7 is a designated officer. Without hearing nothing. And send out the 7. You will decide things.
Lordship, this itself is a ground of appeal.
Please come.
That's a revise all.
Aggrieved by the direction issued by the Deputy General Manager within bracket OPS hyphen ASM for the airport director. Date টা বললাম 3rd July. Dated 3rd July 2024. Annexed at pages 200 and 201 of the writ petition. By advising the petitioner to reduce the height of the building so as to bring the same within the permissible limit. Stop.
But this is in terms of Rule 3, my lord, that order.
A
According to it.
further no objection certificate for height clearance was issued in favor of the petitioner on 20th August 2024 by the general manager within bracket ATM bracketed by ER comma Airports Authority of India, wherein the permissible top elevation of the petitioner's structure has been shown as 51 meter within bracket restricted stuff. The petitioner submits that initial clearance was given to the petitioner for raising construction up to 57.85 meter. Actually, initial clearance was given to the petitioner on 28th April 2016.
For raising construction.
Yes. And the petitioner raised the construction in accordance with the said no objection certificate. Stop. It has been submitted that the height of the building has been unilaterally brought down, reduced by the authority without granting any opportunity of hearing to the petitioner. Stop. The learned counsel representing the petitioner refers to the notification dated 30th September 2015 issued by the Ministry of Civil Aviation, publishing the Ministry of Civil Aviation bracket open height restrictions for safeguarding of aircraft operations bracket close rules 2015, wherein the designated officer has been described. Stop. It mentions that the designated officer is the officer of the Airports Authority of India responsible for processing and or issuance of no objection certificate as specified in Appendix M, Caps M, of Schedule VIII. Stop. The duties of designated officer is for issuance of no objection certificate in respect of civil aerodromes and shall coordinate with the respective locals, municipal or town planning and development authorities in granting approval for construction of buildings or structures. Stop. Appendix M of Schedule VIII provides the list of the designated officers. Stop. As regards Kolkata, the designated officer for issuance of no objection certificate is the Regional Executive Director, Airports Authority of India, Eastern Region. The respondent number 7 herein. Stop. Paragraph. Initially, an issue was raised as to whether the direction for reduction of height was a final order or not. Stop. In the report filed by the respondent authorities, it has been clearly mentioned that the same is not a final order, but it is merely an advisory. Stop. The final demolition order will follow after the same is issued by the Joint Director General or the Deputy Director General of Civil Aviation.
Yes, my lord.
Stop paragraph. As it appears that the petitioner has been directed to reduce the height of the building despite having a no objection certificate issued in the year 2024, pursuant to which the construction was made. Accordingly, the court is of the opinion that an opportunity of hearing ought to have been granted to the petitioner prior to issuance of such direction. Stop. Next. According to the rules as mentioned herein above, rules, 2015, the regional executive director is the competent authority for issuance of the no objection certificate for construction of buildings or structures. Accordingly, the matter is referred back to the respondent number 7 for revisiting the issue all over again in accordance with law, after giving reasonable opportunity of hearing to the petitioner for production of all documents in support of the construction raised. Stop.
And the page 210, I'll just, this is an order of the appellate authority in a similar area. Then yours kindly give me the word.
All documents.
No, this is one building.
210.
An order of the appellate authority in the same area, they've given up to 68.
All documents, you
Right,
rely
all
upon all documents.
Lordship, may kindly record one submission of mine, that the NOC of at page 169 of 2016 and the one in 2024 of different coordinates. They are of different sites.
Already.
Sites,
আচ্ছা,
locations.
একটা সেন্টেন্স যেখানে রেসপন্ডেন্টের বক্তব্য আছে সেখানে একটু লিখে দেবেন। Learned counsel representing the respondent, the Airports Authority of India, submits that the no objection certificate issued in the year 2016 and the NOC for the year 2024 are of different coordinates. Next. ঠিক আছে? আচ্ছা, তারপর আবার ওখানে ব্যাক করে যাচ্ছেন।
So 210 mile can take in
Yes, 210, I have seen that. You
should take them into consideration. This one. But this appellate authority orders is given the same height 60 in the same area.
Petitioner points out to
Order of the appellate authority.
Order of the appellate committee.
Yes, my lord. Sorry. In the same area.
Dated 27th June 2024 for height clearance. Wherein in the same area,
yes,
clearance of height has been given till
68.52.
68.52 meters.
69 also there. 68 is.
Yes, 69.61.
Also.
And 69.61 meters.
Yes.
Paragraph. A decision shall be taken by the aforesaid respondent at the earliest. Stop. Next. Till a decision is taken by the respondent number 7, no coercive step shall be taken against the structure of the petitioner. The petition disposed of. Till a decision is taken, no coercive step at the earliest. I have mentioned at the earliest. The sooner they take, it is better for you.
Yes. What picture of that?
Obliged.
May please, your lords. देखिए अभी तो सर्विस दे।
State, you are there. Medical counsel, you are there.
Everybody is happy.
Respondent number 4, Sanjay Sadhuka.
My lord, here.
Who is respondent number 4?
Complainant. But this is a medical negligence complaint. Complaint, my lord, that I was negligent by virtue of which the lady patient died. My lord, there is a complaint. Complaint is at page 66. I will not trouble your lordship to that. Kindly straight away come to the original order after I objected to original order for punishment has been passed. Kindly come to that order, page 88. This is the order. My lord, will search in vain any reason from this order.
Medical Council's order.
Yes, kindly.
13th of
I
May
am reading with my
24.
lord. This is to inform you that the West Bengal Medical Council at its extraordinary general meeting, such and such, as was communicated to you for hearing of the charges, found you guilty of infamous conduct in a professional respect and decided that the name of the such and such had be practitioner maintained in such and such for 2 years. There is no reason at all.
Infamous conduct?
Why? How? This is an order to be appealed against. Supreme Court, your Lordship's Court, times without number says is an order. If it is appealable, must disclose reason. This is my first point. Second point, my lord, keeping my eyes closed. My client, my lord, I don't know who is advised. Pay for an appeal. I don't know which ground he has taken. There is no ground. Appeal is more dangerous. So far as the finding of the concern, kindly come to the appeal order 91. My lord need not be troubled to the entirety. I will not, because at the motion stage, many things has been written. It starts at 91.
Yes.
The scrutinize, the complaint, the evidence. One thing I mistake, my lord. In the court trial authority, evidence was taken, but no cross-examination was allowed to me. Can you keep a note of that? What is the effect of that? Now, my lord, here is more dangerous thing. Can you see what is the date of the order? Date of hearing, can you come to 91? Date of hearing is 12th August 2024. And now kindly come to yes, kindly come to page 95. Entire thing has been quoted. The appellant prayed for setting aside the order impugned. This is a prayer. Next, before hearing the instant appeal, an expert committee was formed consisting of Professor such and such, such and such, such and such. The appeal was, next page, the appeal was heard at length on 12th August. Next paragraph. The expert committee submitted a report on 16th August 2024 after the hearing. And that is the basis of finding me guilty.
And copy not forwarded to you.
No question, no cross-examination, no copy forwarded. And after the hearing of 12th August, 16th August 2024, committee was appointed. And the committee's report was scanned and found me guilty.
Hmm.
Am I clear to my lord? Then can you see after that, the order, after paragraph 29, the expert opinions has been considered and then found me guilty. These are the 3 points I'm canvassing, my lord. I'm relying on some judgment, if you lordships kindly allow me for this proposition. First of all, my lord.
Which proposition? Reasons to be mentioned.
This is the first one, the original order.
Original order.
Reason order has to be passed because it is subject to appeal.
Yes.
If there is no reason is given, the appellate authority cannot scrutinize.
Yes.
First point, I did not cite. It is in my lord mind. Second is, document relied upon, not submitted, my lord. Can you take at 1991?
No, that is the report. That is the expert committee report which was not supplied.
Yes, not supplied.
Very well.
Second, my lord. My lord.
Second is over. This is the third one. Yes, third one.
Third is, if there is no cross-examination, evidence is incomplete.
Right.
2003 to ICC 441.
Yes. Anything else? No.
These are the points. And 61 Calcutta says, if there is no cross-examination, report need not be looked into.
Very well.
That in a civil suit. But the proposition has to be applied because this is natural justice. Now the point may taken that in the rule there is no provision for supply. Well, your lordship note those laws of judgment. It is natural justice. If it is not specifically excluded, it has to be read into it.
Yes. Medical counsel?
Yes. Today, partner kindly consider the provision of law under which the medical council is acting and the provision of act and the rules.
No, without going into all this, he doesn't say that you do not have the jurisdiction to do it.
No, I'm not. I'm answering his points.
Whether
Of the statute.
the reasoning, it is only the reasoning.
That's why I'm pointing troubling your lordship to come.
Does your act mention that reasons is not required to be mentioned?
Yes.
No reasoning required.
No.
Then that has to be read into. Otherwise, how can he prefer an appeal?
Kindly consider the provision of law under which the council is at. We are not passing any judgments. It was a old act. It was an old one. So many cases is heard.
Yes.
This point was addressed. Even Supreme Court, 5-bench decision, 2 5-bench decision. Somdatta case in 69 and S.N. Mukherjee in 1990. Subsequently, by following the 2 5-bench decision, 2-bench decision, another division bench hold. There is no universal law that every case the law should make a obligation on the authority to give reason. That is.
Are you barred from giving any reason?
Who will pass the reason? Kindly.
No. Who will pass the reason means the council will give the reason.
I am reading section the under which section 25.
Section the rules.
Section the 25.
Yes.
A2 under which this proceedings is called. Whom the power of the council to direct the removal of the names from register and the re-entry of the names therein, the council may direct. 2. We are coming. Whom the council, after due inquiry in the same manner as provided in clause B of section 17, have found guilty by a majority of 2/3 of the members present and voting by way of voting. The voting at the meeting of the infamous conduct of the professional conduct. So, the provision.
Has infamous conduct been defined?
No. Under this.
May I once again disturb your lordship? For infamous conduct, there is a judgment of the division bench where my lord is the author.
Yes.
That I have brought.
Yes.
The charge is not infamous conduct.
Right. I remember that.
I mean, coming.
Yes.
Let's finish that.
Yes, I finished. That's the interruption.
Mm-hmm.
Permission.
We'll come back. It's already 17, right? Because it won't be over in such a short time. So we'll come back.
My lord is not habituated of rising at 1:15. That's why. I know.
No.
I can continue, but it becomes difficult for
Don't
the
continue.
entire
I said don't continue.
infrastructure.
But so far as your staff is concerned, he is not conversant. My lord rises 1:15. So he is not here.
My lord, may I seeking leave to mention one matter for correction, my lord?
No, this is not the time to mention. Please don't mention. Yes. You were referring to section 25. 2.
So the obligation comes upon the council that how to conduct activity. They do it. The rules frame under this same statute. How to we can make the intent. That's and also it is also they have annex the so far the rules.
No, tell me just one thing, whether there is requirement of disclosure of reasons or not. There is no.
It was already accepted by also division bench by Honorable Justice in another matter that since there is no obligation under the statute, we are not bound to give any reason. So this is the
Show me that you are not bound to give any reason.
I am relying only. This is the decision of Honorable Apex Court. I based petition. It is AIR 1969 to AIR 69 Supreme Court, page 414. Somdatto versus Union of India.
Why you are going to such old decisions?
This is the mother decision.
Maybe the mother decision. Show me the offspring decisions, which mentions that there is a requirement of giving reasons.
Just one paragraph. This decision was only on whether decisions must be given or not. Subsequently, another 5 decisions in SN Mukherjee case 1990, it was revisited the decision whether this decision is correct or not. That decision also uphold the decision of the earlier 5-bench constitution, that is the constitution decision. Subsequently, another Supreme Court decision, this point was came out. It is 2010 to Supreme page 39 by B.S. Sidpurkar and Justice Sundar Singh Nijjar. Both are 10 to 2010, volume 2, Supreme. Page 39.
Take the cause title. You can get it in
Union of India.
SCC online, you will get it.
Union of India versus Dinesh Kumar.
Transgression, 1 minute. This I have learned from Mr. Parthasarathi Sengup. He when he joined newly, a judgment is being cited. It is in my mind, it is reported in AIR. He has cited FLR. I tried to find out where I get it. Then I caught him. This is the tricks. I saw FLR, so they could not find out. আরে দাঁড়া ইয়ার কি বুঝা তো সিরিয়াস কেন মামলা তো মক্কেলের
Now,
yes.
5, 6, 10, 12, 14.
পড়তে আমি শুনলেই হয়ে যাবে রিজন দিতে হবে না এটা জানি দেখে বলে দে
The common question, paragraph 5, that calls for consideration in all the appeals can be stated as whether the summary security force court is required to give reasons in support of verdict. Similarly, whether the appellate authority under section 117 is required to give reasons.
This is in connection with the border security force matter. Tell me over here, there is an appellate forum. If an aggrieved person is required to prefer an appeal, what will be the grounds? Because he doesn't know. Tell me only this.
Now, that's why we are relying on the commission paragraph 10 of the mother decision. This category, I am reading, then one paragraph. In the present case,
security force, military.
And tell me one more thing. Apart from giving reasons, you rely upon the appellate authority relies upon a medical report of an expert committee, not a medical report, but a report of an expert committee. Is the petitioner not required to be handed over a copy of the report?
Conclusion of hearing, can you add that? After
Yes,
conclusion of hearing.
after conclusion of hearing.
Established before lawsuit. So for the law framed for the medical council, we have scrupulously followed in the proceedings. We have followed, there's an elaborate procedure we have followed. After following the entire procedure as per statute, as per rules, they have come to a conclusion and they have.
Very well, let me hear the appellate authority once.
There is a provision of alternative remedy, second appeal and third appeal. In 2019, the National Medical Commission Act came into place. This is a central act. Section 30 of the act provides second appeal and third appeal before the appropriate authority.
Who is the appropriate authority over here?
Initially, appeal should be, the first appeal should be before the board formed by the National Medical Commission. And then even someone is agreed, if the doctor is agreed with the order of the board, they can prefer another appeal before the National Commission.
No, here the Principal Secretary, Department of Health and Family.
State Act.
The state act is the governor me.
Section 30.
How many forum is a person required to go to?
State Medical Council, section 30.
The State Medical Council, the first body, the complainant has gone and an order is passed. Challenging that before the Principal Secretary.
Yes.
Department.
There is a provision of appeal.
Against this?
Yes.
All right, show me.
Yes, section 30.
And if there is violation of the principles that has been pointed out, then is there any requirement of sending it to the second appellate forum, or can it remanded back to you?
My case is there is no violation. No violation. As per the rules, we offer to cross-examine. If he decline.
He declined? Where is it? Where is you have records to show that he declined to cross-examine? This is one of the grounds that has been taken.
That's why I'm giving answer.
Where from are you getting that he refused to cross?
From the proceedings.
Yes. Then where from are you getting to know? You must be having something with you.
One paragraph. On completion of the submission and answering question by the charged medical practitioner.
What are you reading?
It is the proceedings of this case before the council.
All right. What is the date of the proceeding?
It was held on 10th February 2024.
February. All right. Yes. What does it say?
Entire proceedings were on completion of the submission and answering the question of the charged medical practitioner, the council offered the opportunity to cross-examine both the parties, which they did not intend to avail of.
None of the parties. That means the
company is also here. So my humble submission at this stage, what is the scope of passing any interim order or not? We have already executed the order. Name was stamped down. Now, if a loss is find that there is a lack of proceedings and then an order is not like to stand, then your loss certainly has power to
set aside the whole thing.
Until
Yes.
that, whether by an interim.
Let me hear these state ones.
But I am settled with two questions. One, that after the hearing was concluded, how the report was taken and without giving him an opportunity, how that report has been relied upon by the appellate authority.
To the disadvantage of the petitioner.
To the to some extent, yes. But if I can show from the record as annexed in the writ petition that there are admissions. What is the fact? Nobody has said the facts. A lady was admitted by the doctor, the writ petitioner here, in a nursing home. Her family had faith in him. She was operated at 9:40 a.m. Cesarean. Then the doctor left. He claims that I have given charge to some other doctor. The profuse bleeding was there after 4 p.m. He didn't turn up. He didn't turn up. Resultant effect is for the profuse bleeding, he died. That is the postmortem report as well. So in such a situation, the questions were put to the doctor. Kindly see that page 71. If your lordship finds that on admission it should go, then my lord.
Yes.
My lord, it starts with deposition of Dr. Gauranga Ghatak, who is the writ petitioner here, on 15th of June 2023. First paragraph not required. He claims that I am MBBS from Rajshahi Medical College in the year 1974. Thereafter, I obtained following postgraduate qualifications. Address is given. At present, I am attached as retired from Health Department in the Government of Hospital. Then the question starts. Please provide details as to how you obtained Indian citizenship from Alipur Court.
Alipur Court, you obtained citizenship?
Unknown to a person. Unknown. Citizenship, it is known to me by birth.
Then
the next question.
And the qualification is also from Rajshahi. 1974. All right, then.
Who were your assistant? Dr. Devasis Ghatak. Did you hand over charge to Dr. Arindam Majumdar? Yes, this your lordship kindly mark. How was Dr. Jagadish Chandra Burman involved in the management of the patient and anesthetist? When did you get the news about the deterioration condition of them? He says nursing home. Was there any blood test not required? Kindly come to the next page. Please provide the PM report of the patient in the police station. Did you check the pallor of the patient post-operative? Yes. Was the operation uneventful? Uneventful? Yes. What can be the cause of bleeding in the abdomen? Question number 12. What can be the cause of bleeding in the abdomen? As was evident in the postmortem report, might be slipping of ligation.
Ligation.
Ligation, yes. Who had suggested autopsy? If it was you, why did you suggest it? Me, because I was not sure about the cause of death. Who had measured the BP? Ward sister, RMO, anesthetist, me. Was the RMO a qualified one? Yes. Did you think that you had been present in the nursing home, you could have saved the patient? All measures taken to save them. These are avoiding. But after the cesarean section, a doctor is required to stay for at least 4 to 5 hours in the same nursing home. Was there any PV bleeding? Did you check that? How was the abdomen? No PV bleeding, abdomen check could not be assessed due to ventilation. Did you agree that there was failure on your part in diagnosing the cause of determination of the patient? It happened so suddenly that diagnosis was difficult. Do you think that the management of the patient was a BP of
90 by 60. 90 by 60.
Yes, sir. I heard you. You were doing my duty was appropriate by the RMO. RMO rightly shifted the patient to ICU. Do you accept that the patient was dead when he was transferred to ventilation? No, patient was put to ventilation in serious condition but living condition. How could he say? He was out. He was out. Very well. You will get your turn in. Consequent upon taking deposition of the concerned doctor, then kindly come to. He has said about Orindam. Question. I am showing. Kindly come to page 71. Question number 3. He said that I have handed over 71. Please. Got it? Then kindly see the deposition of Orindam at page
73. Yes.
Question number 1. What was your involvement in this case? I was not involved in this case. I did not visit the patient. I was not asked to visit. This is a careless doctor's. One after another operation, one nursing home to another, and patient will die. Did you have any idea about the post-operative management patient? I heard about that. He has heard. Then, my lord, Orindam signs on 27th of July. Then, this tantamounts to, my lord, an admission that he was out and he was not in the nursing home. He handed over charge. Then kindly come to, my lord, another deposition of Dr. Kaustubh Saha. My lord, I am skipping. Kindly come to page 74. Page 73, your lordship got it?
Yes, yes, I have seen
Kindly come to page
74.
74. Question 5. Who had opted for the postmortem examination? Dr. Ghatak, that is Petition himself, opted for postmortem. Deposition of then, my lord, another of Dr. Dipa, nursing, Dibendra Basu, Bose. Question number 3. না না জজ সাহেব পড়ছেন গোটাটাই আমি এখান থেকে বুঝতে পারছি তো কোন জায়গায় কলমটা then this is the condition, my lord. He himself starts the responsibility. It's not required. Kindly see Orindam and, my lord, the petitioner before your lordship. He himself says that I have given charge to Orindam. Orindam denies. And patient died. And, my lord, this is the, my lord, whole set of facts. 9:40, you are operating a patient. You took the decision to operate. And you are leaving. Coming back at 4 p.m. when the patient is in ICU. Petitioner, the complainant is claiming that dead body was put to the ICU. I do not say anything about that. Question, my lord, kindly come to deposition of Gauranga Kumar Ghatak at page 76. Kindly skip the question. Has your lordship got it?
Page
76.
Yes.
Kindly come to page 77.
Yes.
Question 8.
Yes.
What was the reason for your absence after the CS? Cesarean section. Serious condition of my mother at 30-45 minutes distance from where I can come back quickly. The same time I was engaged in major operation when my patient is in problem is looked by other colleagues. He is not explaining who was the patient, where you had been. You are just living. Next question. Did you hand over the patient to any other qualified colleague? Yes, again he is repeating. Yes, I asked Dr. Arindam Mazumdar to attend the case if situation arises. But when the BP, then it's not. But when the BP of the patient become low, I thought it might be delayed spinal effect. So I called the attending anesthetist. He reported that the patient is normal and there is no crisis. Which he is taking information from the anesthetist. Then kindly come to question number 10. You kindly see, I did not call Dr. Arindam Mazumdar to see the patient. He is relying on my lord anesthetist. Then the doctor who he says to be has given charge of the patient. If this is not carelessness, my lord, infamous.
No, but then tell me whether there is any requirement of recording any reasons. And secondly, you said there is admission.
That my learned friend is competent enough because he is representing
All right. Then
I am representing the appellate authority.
right. Now, appellate authority relies upon
One question raised by
the appellate authority relies upon a report of the expert committee and with not giving a copy, and that too after the hearing is over.
That I am answering.
Yes.
I should answer, madam. He may be infamous, he may be negligent, but as to whether the proceeding.
One thing, infamous is not the charge.
Very well.
Yes.
Negligent.
Next.
Sorry.
Infamous, I am saying because you come from some other country.
You cannot say this. The charge will say.
Yes. You.
Is that the
What is your
answer to that is, your lordship knows, my lord, all secretaries of the state government or any other government are IAS officers. They are not.
Immune. IAS bole.
I am not saying that. You are putting words in my mouth. They are not medical experts. What happens, my lord? After the records are brought to him, and after he gets this, he takes an opinion. After hearing parties, he takes an opinion of the expert. And kindly see the expert's opinion. Kindly sees.
Is it annexed?
No,
Yes.
it's recorded. I've been charged with only on the expert opinion.
Yes, you mentioned it is recorded.
Kindly see the
After paragraph 29.
expert opinion.
20 paragraph 29 also.
Paragraph
29.
The pages are not, my lord, properly arranged in my brief.
95. 95.
Page 95.
Yes, 95.
Come after page.
After 32, paragraph number 32.
I am sorry for that.
Page 95.
5.
My lord, it is.
No, what
some,
time?
না দাঁড়া আমার মার্ক করা আছে আমারটা বললে হবে না ভাই Yes, kindly come, my lord. Question number 29. The appellate press for setting aside the order in plea. Before hearing the instant appeal, an expert committee was formed consisting of doctors such and such, of NRS, such and such. A qualified doctor was. Then, my lord, kindly come to page 95A. The appeal was heard at length on 12th of August 2024 in the presence of appellant, then Sanjay Sadhu Khan, the husband of the deceased, expert members were present also. And the registrar, West Bengal Medical Council. The expert committee submitted a report. What is the wrong in it? If they were heard and report is filed, your lordship always said you file a report. Even after the conclusion, you file a written notice of argument.
No, this is not a written notes of argument.
Yes, report. I am saying report. But kindly see, a person has been assigned the appellate authority designator in the act, and he is always IAS in all cases. My learned friend was saying something that charges are not infamous. Kindly come to page 83.
Yes, I've seen infamous conduct.
First conduct.
Lack of monitoring and absence of timely intervention. What will be your reply for the interim relief right now?
Believe if it is, my lord, the point I about canvas, so-called admission, Mr. They could not show to your lordship, my lord, any admission. I have not find any admission.
He left. When he
I say I left.
When you were required to stay.
Who says so?
Oh, you will cut and then go.
This is, my lord, this is not from the bar. From the record, he has to come. Whatever required to be done, I have done. And we are not on that today, probably. My contention before my lord is, even if it is admitted, I'm going to that extent my case. But kindly see the order. It is on the basis of admission. Let us once, kindly pardon me for traveling, lordship, kindly come to page 88. This is the order which has been appealed against. Kindly see. This is the order by the West Bengal Medical Council. Is it, I am asking the question, is it by admission? Answer is no. This is not on admission. I have not been charged. Not been proved. My charge has not been proved on admission. 88, my lord has got it.
Yes.
My lord has read that.
I have read that.
Unanimously decided. That's all. No reason, nothing. I have appealed against this order. My client who's been properly advised to approach in this stage before my lord to come. And the appellate authority, what they did, see, discussed everything, but not convinced with the order of the lower authority. It itself appoint an expert committee, and the finding, you will also kindly see after paragraph 29, your lordship will find that only on the basis of the expert report which was examined after the conclusion of the hearing, the punishment has been affirmed. So, my lord, to score, I said natural justice has been violated. I can explain, my lord, as a doctor, he has operated, he may have some other work, but it is duty to look after the patient and to manage that. It may happen, my lord, in your lordship's experience had seen a patient who was talking to the guest. Within 1 hour, he may collapse. Only thing is whether he was properly attended or not.
Was he attended in this
Yes.
case? How?
When he left, thereafter he was rang that the patient is deteriorating. He asked by his phone, then come back.
No, but then in the meantime, a lot of time elapsed.
Well, not lot of. There were other persons there.
No.
A nursing home cannot be without any doctor.
Cannot be, but here he relies upon some. What is his
That is
name?
Arindam, he denied. But this has to be scanned by the authority after coming to. My lord, in oath to oath, the lordship is every day is doing.
I say something, the other side denies. It has to be, there are other reasons. He can check the BH, means bed ticket. It can be looked into. But I will not go into that question. This is not the finding against me.
No, all these culminated in the finding.
What is the reason? I'm asking again. There is no reason. Had it been a single reason, my lord, single line of reasoning, that due to this, you are negligent. My lord will find in vain. And so far as appellate, I have already, my lord, canvassed before my lord.
Yes, I have seen. But then
4:30 তে ওনাকে কন্ডিশন খারাপ দেখে আইসিইউ তে ভর্তি করা হয়েছে, আইসিইউ তে শিফট করা হয়েছে।
Yes, that has not been denied by the appellate authority.
Everything has been recorded.
So, well, kindly come to about after 29.
Expert opinion of Dr. Tubesha Bakula. Kindly read. Kindly read page 78 and page 79. Everything is clear here.
But I should not interrupt when others are making submission.
But will interrupt.
But he was absent. Is at page 93A, clause V.
Where I have said I have present, I have never said. I say that I went to see my mother, and my lord, the patient was up to 4 p.m.
There is no post-operative note. A chart is followed.
No post-operative.
From 9:40 to 3 p.m.
The patient was
left in the God's hand.
But what can be done up to my lord? 3 p.m. patient was examined by Dr. Borun Bormon. Then, my lord, at 4 p.m. patient was extremely well, examined by the RMO. And 4:30 p.m. the condition deteriorated. Everything has been reported to me. I was constantly giving the advice.
Put to ICU.
Then he was put to ICU, then I came back. And these are not, my lord, the finding of both the authorities. Oh, my lord, certain thing has been tried to prejudice, my lord, that I am from Rajshahi and this, that I am MD from India, Calcutta University. And if your lordship kindly once come to page 70, I am MD from India.
that is your deposition. You have mentioned that.
Yes.
I have seen that.
Page 82, if your lordship once
Yes,
come.
yes, I have seen that.
So it is not to prejudice that I am from outside. That's why this is only to, my lord, to prejudice me.
Page 82 তে আছে।
चल हमके registration दा है।
The petitioner is aggrieved by the order passed by the West Bengal Medical Council on 13th May 2024. Directing removal of his name from the register of registered medical practitioners for a period of 2 years. Stop. On an appeal preferred against the said order, the same stood affirmed by the order of the Principal Secretary, Department of Health and Family Welfare on 6th September 2024. Stop paragraph. The petitioner challenges both the aforesaid orders, primarily on 3 counts. Stop. First, the order passed by the Medical Council is a cryptic and unreasoned one. Stop. The petitioner was not given an opportunity to cross-examine the witness. প্রথমেরটা হলো cryptic, সেকেন্ডটা হচ্ছে opportunity of cross-examination. It is second. And third is reliance of the report of the expert committee. Without providing such report to the petitioner. Stop. Paragraph. Prayer has been made to prayer has been made for grant of interim relief by staying operation of the impugned orders pending disposal of the writ petition. Paragraph. Learned counsel representing the medical council submits that all procedures in accordance with law were followed at the time of deciding the complaint filed by the complainant. Stop. There has been no violation of the principle of natural justice. Stop. There is no requirement of providing detailed reasons in the order passed by the council. Stop. Paragraph. Learned counsel representing the state respondents has placed reliance on the deposition annexed to the writ petition. Stop. It has been submitted that the petitioner practically admitted that he performed the operation in the morning and left the nursing home at around 10:30 a.m. and returned so late, by which time the condition of the patient deteriorated and she expired. Stop. So late.
Oh, so late.
It has been pointed out that the explanation provided by the petitioner for leaving the nursing home is not proper. Stop. A very vague explanation has been given that he went to visit his mother. Stop.
And another operation.
It is also pointed out that though the petitioner deposed that he handed over charge of the patient to a separate doctor, but the said doctor has categorically deposed that he was not given any charge of the subject patient. Stop. It has been submitted that it was the responsibility and the duty of the doctor to take care of the post-operative period, but without doing so, he left the nursing home without proper precaution, for which the patient died an untimely death. Stop. Paragraph. Learned advocate representing the complainant submits that the report of the expert committee was very much within the knowledge of the petitioner. Stop. The same is also reflected in the order passed by the medical council. Stop. Paragraph. At this stage, the writ petition is being considered for grant of interim relief. Stop. It appears that The petitioner is aged about 74 years. Stop. Next. The conduct of the petitioner as reflected in the depositions and all the documents annexed to the writ petition suggests that the petitioner conducted a surgery in the morning of the fateful day at around 9 o'clock, and he left the nursing home at around 10:30 a.m. Stop. It does not appear that he handed over charge to any other separate doctor to treat the patient in case of an emergency. Stop. It is only a regular practice of the doctor to call up any other doctor in the nursing home to attend a patient in case of an emergency. Stuff. The doctor the doctor on whom the petitioner submits to have handed over charge has plainly denied that charge was handed over to him. Stop. The said doctor has clearly mentioned that he was not involved in the case, and he did not visit the patient and was also not asked to visit the patient. Stop. The very fact and the very statement that the petitioner made regarding handing over charge for post-operative medical emergency is denied by the doctor in whose favor the petitioner relies upon. Stop. Next. The a report of the medical expert annexed with the order of the medical council not the order, the proceeding of the medical council is such that the court is not convinced to grant any interim relief to the petitioner at this stage. Stop. Next. The respondents are directed to file report by way of affidavit. By how soon can you do it? A doctor's registration has been cancelled and you say 4 weeks. Do it by a fortnight.
Now there is a problem. There is no register due to order of the High Court. So new register will have to take over the charge.
Yes.
Now,
somebody must be officiating.
Yeah. In trouble.
How is the medical council functioning at this stage?
Last week, the division bench of appeal matter asked the register, the acting register, to step down, and he has acted upon. Now also filed an application. I don't know. Now there is no register. They have already. I have, as per information, they have already recommended name to the government. Now after the government.
Very well, by 3 weeks. A reply, now exception to the report may be filed within a week thereafter. Stop. Let the matter appear in the list immediately upon completion of the aforesaid time period. Affidavit of service is taken on record. You handed over certain document, I see signature of the registrar. Take all these back. Take all these back. The court is not looking into anything at this stage. Take back everything.
Am I opposing it? I am for
I
the
appear
W's.
on the petitioner, madam. The petitioner is an educational institution. The petitioner is regularly paying the electricity charges. After coming into effect of new tariff regulation in 2024, after April, my lord, havoc demand charge is being imposed upon the institution against the provision guideline of the tariff regulation, and abruptly, without giving any opportunity of hearing, the electricity connection is disconnected. Electricity is disconnected on December 2, on 2nd December. So, my lord, may I come to the regulation, my lord?
Tariff schedule is
Billing dispute. It's a
Tariff
billing
schedule.
dispute,
It is-
and the matter is to be referred to the RGRO. It can be resolved by the RGRO, but the no application has been filed for the RGRO.
Violation of principle of natural justice, my lord, I can show, my lord. I can
Notice
show,
has
if I
been
can
given
show,
for disconnection.
if I can show, without giving any opportunity of hearing, without giving any notice. And they are giving a notice on 16th January, 15th January, that electricity will be disconnected if I do not pay 1,39,884. But in fact, my lord, I can prove. You lordship kindly see. The
What
electricity,
is this? What
They
is
have-
this?
drawn a bill on 4/1/2025.
That means if there is a billing dispute.
No, my lord. There is nothing, no energy charge, nothing, because the already electricity connection is withheld. Electricity is disconnected on 2nd December 2025, 24, 2nd December 2024. So, my lord, according to the CDL 12 of the tariff regulation, the educational institution is low and medium voltage consumer. Low and medium voltage consumer is 50 kVA and above, up to 200 kVA. The connected load, my lord, is 88 kVA. So according to the schedule, the rate is 100, but they are now charging, my lord, 274.
That means there
Treating
is
me-
a dispute for which there is you.
No, treating me as commercial consumer.
I have followed it.
My
Now
lord.
who is going to decide?
My lord, you lordship, my lord, kindly see at a glance, my lord.
Who
My lord,
will decide? This court will not decide the billing dispute.
it is not billing dispute. It is on the face of the record. They are, my lord, doing, my lord, malafide and vindictive, my lord, action against the college, my lord. Kindly see, my lord. Tariff regulation. My lord, page 36, my lord. Serial 12. Private educational institutions and hospitals. Demand charge rate 100. Page 36.
Yes.
Serial 12. 100. And next page, my lord, serial 16. Commercial consumer. 50 kVA and above. Rate 270. My lord. Now, my lord, come to the bill, my lord. What they are charging.
They have charged wrongly.
Not wrongly, my lord. Intentionally, my lord. Because
intentionally they have done a wrong.
It is not wrong, my lord. It is vindictive and malafide.
Vindictive attitude. Who is going to rectify it?
My lord, kindly, my lord.
Who will rectify it?
Yes, my lord. In the meantime, they should connect the
Very well.
electricity. It is an educational institution. Kindly see the
Stop.
bill, my lord, kindly see the bill, my lord. If you lost it, kindly, my lord, please, my lord, 56. My lord, connected contract demand.
Please
That
come.
right hand side, my lord.
The petitioner is aggrieved by the
88 kVA.
amount raised in the electricity bill by the West Bengal State Electricity Distribution Company Limited. Step. The petitioner submits that the petitioner is an educational institution and is to be charged energy at a fixed rate of ₹100 as applicable for private educational institutions and hospitals.
Per kVA.
Per kVA. Stop. The authority applied the rate meant for commercial consumers within bracket 50 kVA and above at the fixed charge of ₹270
274. 270. Sorry, ma'am.
per kVA. Stop paragraph. It has been submitted that the same is the intentional and vindictive attitude of the Electricity Distribution Company Limited in raising such high energy bill. Stop paragraph. The petitioner has made representation through an advocate before the superintending engineer / divisional engineer. The same is yet to be disposed of. Paragraph. Upon hearing the submission made on behalf of the parties, it appears that the billing dispute and that the issue relating to billing dispute is to be resolved by the regional grievance redressal officer.
As per regulation 3.1 of clause, that is a regulation 55.
As per regulation 3.1.
As per clause 3.5.1, regulation 55.
3.5.1 of regulation 55. What a clause 3.5.1. Regulation 55. Stop. The petitioner is yet to make any application before the aforesaid authority for redressal of his grievances. Stop. Next. The institution in question is without electricity since 2nd December 2024. Stop. Paragraph. Leave is granted to the petitioner to apply before the regional grievance redressal officer at the earliest. Stop. In the event such an application is made within a week from date, the same shall be disposed of by the RGRO in accordance with law at the earliest, but positively within a fortnight thereafter. Stop. Paragraph. If the grievance of the petitioner appears to be proper, then necessary consequential steps shall be taken immediately thereafter. Stop. The writ petition stands disposed.
Since no affidavit has been taken out, all allegation is
139,884 only, my lord. We shall pay 50%, my lord. The connection be restored, my lord.
You have already waited for 2 months. Wait
No,
for
no,
one
my lord.
more month.
My lord, immediately after disconnection,
Yes.
my lord, I filed the application, my lord. My lord, kindly, it is an educational institution, my lord.
Call the next
My
one.
lord, students are suffering much, my lord.
In item number 8, I am appearing for the petitioner.
Yes.
Petitioner of the first in the first writ petition, I am appearing for the petitioner, and in the second writ petition, I am appearing for the private respondent.
I am for the in item number 8. I am for
Petitioner.
the private respondent, and 9. I am for the petitioner.
Yes.
This is a case for illegal conversion of a fund.
You are for
You know, the earlier occasion.
Not this week, my lord.
No adjournment.
Direction upon me.
We have given a spot inquiry report. Initially, one of the petitioner appeared. In the second instance, after we have issued a notice, the BLO and all parties were present. I am furnishing the report.
Let me see. Water body converted to land without permission from the appropriate authority. And then conducted another to them so that they also get to know what is there.
My lord, liberty may be given to file an exception to the report.
Exception over there. What will the court do by looking at the exception? Please come. Report of joint inspection of plot number 1064. Mauja Gaur, Behrampur. Prepared by the Executive Officer, Behrampur Municipality. On 7th February 2025. Is placed before this court. Stop. The report of the Blockland and Land Reforms Officer, Shodor, Behrampur, Mushidabad, signed on 7th February 2025, is attached therewith. Stop. It appears therefrom that a joint inquiry was conducted in the presence of the parties and in the presence of the representative of the Behrampur municipality and the representative of the land authorities. The plot in question was identified and a sketch map prepared. Stop. It was found that plot number 1064 recorded in favor of Arun Kumar Guho and others is recorded as Pukur in the record of rights. The said land has been filled up. Stop. Paragraph. As it has been conclusively proved that as the Blockland and Land Reforms Officer and the municipality have come to a finding that the land is a water body. Accordingly, it will be open for the authorities to ensure that the character of the land is not changed in any manner whatsoever. Stop. If in the meantime the water body has been filled up, then necessary remedial steps shall be taken to restore the water body to its previous condition.
Only one number submission. If you also kindly mention that municipality has taken action as per West Bengal Inland Fisheries Act. Because the BLR has given any conversion.
No, BLR is not given. It is open for you.
Only one, kindly ask the police authority to render assistance.
Yes. It will be open for the competent authority to take the assistance of the officer in charge of the concerned police station at the time of implementing the direction passed herein above. Both the writ petitions disposed of.
Much.
My lord, in this matter, Mr. Sushana Bandyopadhyay appearing before state, my lord, he's on his leg before court number 36. I'll kindly adjourn for the day, my lord.
No adjournment.
Heard on the last occasion considerably. My lord, kindly
adjourn.
remember
There is another counsel. I can see her name recorded over here.
My lord.
Where is she?
Amrita Panja Maulik, my lord.
Yes, I can see. Where is she? The said report was taken into consideration by the other person market value. Yes.
This
My lord,
matter was
kindly
was-
for the 1 day, my lord. I am praying for the 1 day accommodation, my lord.
This 1 day will go to a month.
No, no, my lord. My lord. Give it
This
tomorrow.
bench, the functions of this bench, the work of this bench will not permit. For you, it may be 1 day. But the convenience of the court is required to be looked into. What can be done? Yes. Land situated in front and the land situated at the back.
My lord, your lordship heard this matter on the last occasion. Your lordship's desire was, my lord, to show some authority how the scope of writ petition. So, my lord, I am prepared, my lord, on that. But before that, my lord, may I place your lordship, my lord, the law. My lord, just a minute. But the Stamp Act, if your lordship says, my lord, under section 47A, my lord, there is the reference to the collector.
Yes.
And the collector will adjudicate the market value. Against that, appeal is under section 47B. Now, 47B, my lord, this is the impugned order is under 47B. Now, my lord, kindly comes to the definition, my lord, page in your lordship's book, my lord, page 18.
Page 18.
Page 18, 18. The definition of the market value.
Yes.
My lord, market value, West Bengal Amendment 16B. My lord, means in relation to any property which is the subject matter of an instrument, the price which such a property would have fetched or would fetch if sold in open market on the date of execution of such instrument, as determined in such manner and by such authority as may be prescribed by rules. Here I am on, my lord, made under this act, or the consideration stated in the instrument, whichever is higher. My lord, according to my consideration, it is 33 lakhs, but according to them, it is 3 crore 16 lakhs. Whichever is higher, that has to be done. But my lord, as prescribed under the rules. Now, my lord, when dispute is raised, my lord, kindly comes to page 42. 47A.
Yes.
47A, my lord, states that instruments of conveyance, etc., undervalued, how to be dealt with. Now, when the registering officer appointed under the Registration Act has, while registering any instrument of such and such, then, my lord, and transfer of lease up to H, I am not reading, my lord, reason to believe that the market value of the property which is the subject matter of any such instrument has not been truly set forth in the instrument presented for registration, he may, after receiving such instrument, ascertain the market value of the property which is the subject matter of such instrument in the manner prescribed and compute the proper stamp duty chargeable on the market value so ascertained and such, my lord. I am not troubling your lordship with the other portions. Now, kindly comes to the rules statement, my lord. That is, my lord, at page 153.
Yes.
Rule 3. This is, my lord, the West Bengal Stamp Prevention of Undervaluation Instrument. Rule 3, my lord, states manner of determination of market value and furnishing of particulars relating to any property. The market value within the meaning of clause 16B of section 2 in relation to any land or any land with building shall, after taking into consideration the particulars referred to in subrule 2, be determined on the basis of the highest price for which sale of any land or any land with building of similar nature and area and in the same locality or in a comparable locality has been negotiated and settled during the 5 consecutive years immediately preceding the date of execution of any instrument setting forth such market value, or on the basis of any court decision after hearing the state government, or on the basis of information, report or record that may be available from any court or any officer or authority of the central government or the state government or any local authority or local body, or on the basis of consideration stated in such instrument for such land or land with building whichever is greater. Now, my lord, here they have not followed this principle. Comparable sales method is the only method, my lord, which is the best method which has to be adopted here as per the rules.
And your
Yes, it is
your
same plot,
document is there.
19 kathas. It is the, my lord, there cannot be any best evidence, better evidence than the property which has the portion of which has been sold, and the valuation was determined by the government.
This is the same submission that you made on the last occasion
Yes.
also.
Your lordship's authority, my lord. My lord, so far as the scope of the jurisdiction, if your lordship desires, my lord, I can, because your lordship, my lord, insisted me. My lord, Supreme Court has been very categorical, my lord. I have tried my best, my lord. My lord, this is at 2008, volume 4, SCC 720. Paragraph 28, your lordship kindly comes to. 2008, volume 4, SCC 720.
Yes.
My lord, kindly comes to paragraph 28, page 736.
Yes.
Paragraph 28. We may, however, consider a hypothetical case, supposing the, my lord, here, my lord, this case, my lord, revolves around the whether section 47A is ultra vires the constitution, this and that. So 28. We may, however, consider a hypothetical case, supposing the correct value of a property is rupees 10 lakhs, and that is the value stated in the sale deed. But the registering officer erroneously determines it to be, say, rupees 2 crores. In that case, while making a reference to the collector under section 47A, the registering officer will demand duty on 50% of rupees 2 crores, that is duty on rupees 1 crore instead of demanding duty on rupees 10 lakhs. A party may not be able to pay this exorbitant duty demanded under the proviso to section 47A by the registering officer. In such a case, what can be done in this situation? Paragraph 29. In our opinion, in this situation, it is always open to a party to file a writ petition challenging the exorbitant demand made by the registering officer under the proviso to section 47A, alleging that the determination made is arbitrary and or based on extraneous considerations. And in that case, it is always open to the High Court, if it is satisfied that the allegation is correct, to set aside such exorbitant demand under the proviso to section 47A by declaring the demand arbitrary. It is well settled that arbitrariness violates Article 14. My lord, if your lordship comes to the impugned order, your lordship will find that they have set forth the valuation. My lord, prior to that, my lord, when this matter was, my lord, moved before Honorable Justice Mosmi Bhattacharya, your lordship remembers it, that page 108, that it cannot be. So there was a further direction. Now, my lord, kindly comes to the impugned order. Although this honorable court directed the reappreciation of the market value, how the impugned order was made, my lord, page 113, from the last paragraph. During physical inspection as fixed by you, you were requested to kindly take real-time picture in consultation with the aggrieved party. You must take real-time picture and submit in next hearing on the present condition of the building and such and such. From the report sent by the DIGR 4, Bardwan, it is found that as per the deed number 7102/2020, total market value of 7,063.5 square feet land with 5,000 such and such is rupees 3 crore 10 lakh 16,000. This is wrong. It was just the other thing. The two deeds, my lord, this should be 1 crore and 19 lakhs. As per the pending deed number 778, total market value is such and such. It may be pointed out that the structure was 37 years old, and then they went on with the depreciation. They're giving some concession on that market value only, and some depreciation regarding this, and they gave a decision, remission of some 57 lakhs. No reconsideration of the market value at all. Now, my lord, the report. My lord, they placed, my lord, Mr. Bandyopadhyay on that last occasion placed a report. Your lordship, my lord, granted me liberty to consider it and come back. If it is with your lordship, my lord, the report that was handed over, my lord, probably on the last occasion, because a copy was given to me also.
Report dated 22nd May of 2023, my lord.
2023.
How big is the report? Is it voluminous?
No, my lord, the report is not voluminous, my lord. This
4
is,
pages.
yes.
I see the
It
order
was
sheet
served-
dated 15th of May, 2020.
Yes. The 15th of May, 2023.
Yes.
It starts with that order.
All right.
Now kindly comes to the second page.
Second page.
No, my lord, if we take the last line of the first page, this is how they have come to this quantum. After careful scrutiny of the pending deed serial number 778 as well, the following points are found. Reference plot number at rate per kata 10 lakhs. 10 lakhs. Where from, my lord? Nothing. There is no, my lord, no material evidence on the basis of which they have come to this conclusion. Shop on ground floor, rupees 5,000 per square feet. Office on the first floor, 3,000 per square feet. Residential structure, 450 per square feet. And in this way, they came to the conclusion, they summed up the entire thing and they put the total market value 3 crore 10 lakh 16. And this way they have justified it. My lord, on this point, my lord, if your lordship allows me, my lord, I have some authorities to show, my lord, that how this assessment should have been done. My lord, this is AIR 1982 Madras 138. AIR 1982 Madras 138.
Yes.
Paragraph 15, my lord, kindly comes to. My lord, here, my lord, the appellate authority's decision was upheld by the High Court. At the end of the discussion, I may observe that the rationale behind section 47A of the Stamp Act is only to neutralize the effect of undervaluation of property with a view to evading stamp duty. This object behind the section has been very well brought out in the division bench ruling of this court in state of Tamil Nadu versus Chandrasekharan, AIR 1974, Madras 117. The following observations in that case are pertinent. We are inclined to think that the object of the amending act being to avoid large-scale evasion of stamp duty, it is not meant to be applied in a matter of fact fashion and in a haphazard way. Market value itself, as we already mentioned, is a changing factor and will depend on various circumstances and matters relevant to the consideration. No exactitude is in the nature of things possible. In working the act, great caution should be taken in order that it may not work as an engine of oppression. Having regard to the object of the act, we are inclined to think that normally the consideration stated as the market value in a given instrument brought for registration should be taken to be correct unless circumstances exist which suggest fraudulent evasion. Well, there are other authorities, my lord, Supreme Court also said that, but the onus lies on the government. And there too, my lord, show that with material evidence that no, this is wrong and this should be correct. So there is an evasion of stamp duty on your part. Otherwise, my lord, it cannot be simply in this fashion. Now, my lord, here, my lord, in paragraph 16, lordship says it was not the case of the collector that he had before him, for purpose of comparison, any contemporaneous sales of other estates in the vicinity during the material time. As observed by the appellate authority, the one and only sale.
Yes, I have followed it.
Yes. Now, my lord, here only one thing, my lord, in paragraph 17, if you see your lordship, my lord, here, my lord, the court has given weightage to this fact that here also, my lord, the Reserve Bank of India and the Tea Board, my lord, they, my lord, subscribed to this assessment, the valuation assessment, and court held that they do not have any vested interest in assessing the valuation of the property, and they are, my lord, public bodies. My lord, in my case, my lord, you also will remember here, my lord, the State Bank of India, my lord, they approved the valuation and granted us loan, and the insurance company, my lord, the properties.
That is the other plot.
No, this plot only.
This plot. All right.
Approved the valuation, 33 lakhs and odd, and the New India Assurance Company. None of the private insurance companies or any other private limited bank. They also, my lord, approved the assessment. For the
right.
Now, my lord, kindly comes to my lord, this is a
Yes, state, would you like to submit anything? Because I'll be passing orders just now.
one point, may I?
Yes, one
apprise
point,
for
which point?
Lion petitioner saying that on the which basis the valuation was asserted. My lord, one, I may not equate with the rules, my lord. One, only rule 3.1 I just want to indicate it, my lord, your lordship. Rule 1 says that speak that the market value within the meaning of clause 16b of the section 2 in relation to any land or any land which with building shall, after taking into consideration of the particular referred in subrule 2, be determined on the basis of the
please come.
highest price of which sale of any land or any land with building similar nature in the area, in the same locality.
The petitioner is aggrieved by the order of the commissioner, Bird 1 division and the appellate authority under section 47B of the Indian Stamp Act, 1899, dated 25th of May 2023. Stop. The aforesaid consideration was allegedly in the light of the decision passed by this court on 25th April 2023 in WPA 20974 of 2022, the court took note of the difference in the valuations arrived at for the back and the front portion of the same property and found the same to be excessive and without due cause. Stop. The court also took note of the fact that the property being located in a busy commercial intersection of Bird 1 is not sufficient to justify the disparity in the valuation. When the back portion of the property has been valued at rupees 1.19 crore as recently as in 2020. Stop. Paragraph. The commissioner assessed the market value of the front portion of the same property at rupees 3,10,16,000. Stop. Paragraph. The impugned order mentions about the depreciation that has been allowed on the structure of the ground floor and the first floor, maintaining the government norms. Stop. Paragraph. The impugned order does not take note of the market value of any property of the locality or nearby. Stop. The best piece of evidence with regard to the market value of the said property will be the deed in respect of the back portion of the same property which was registered in the year 2020. Stop. Paragraph. From the recording of the order sheet dated 15th of March 2023, the differences with the differences of valuation, difference
Well,
of
15th
valuation.
of March is not the order, my lord. It is the report.
The serial number and the date of the order is mentioned. This is the proceeding order sheet. At the top, it is written order sheet from 6 July.
Yes.
So this is the continuation of the order sheet. The difference of the valuation between the front portion and the back portion has been justified. Stop. Next. Even at
My
the
lord,
time,
this is also not, my lord, I'm sorry to interrupt, my lord, possibly there is something, my lord, this is also not the continuity of the order. The order sheet, my lord, if your lordship sees, my lord, it is annexed. This is the report based on which this impugned order was passed. Kindly compare these two, my lord. Then this is an appeal number 14 of 2019 has been disposed of.
Yes, yes.
Based on some report.
This is the report.
Yes.
This is
my lord,
signed
the
by
order
the-
was passed by the commissioner, Bardwan division.
Yes, yes. This is
And
by
this
the
report is, my lord-
DIGR.
Yes, lord. So this is there's something.
আচ্ছা ওটাকে রিপোর্ট করে দিন রিপোর্ট অফ দি না সেম 15th 18th May 2023 18th May 2023
Impugned order is, my lord, of 22nd May. Page 113.
আচ্ছা 15th May, 18th May দুটো আছে
22/5/2023 in appeal number 14.
DIGR range IV Bardwan. Mentions about the reasons for difference of valuation. Reasons for difference of valuation between the front portion and the back portion. Justified আসবে না ওখানে আগে বলে দিচ্ছি reason. ঠিক আছে? The fact of the norm of depreciation being applied is also mentioned in the said report of the DIGR. Stop paragraph. When the property in question is the same, comma, the difference in valuation of the front and the back portion appears to be shockingly disproportionate to each other. Stop paragraph. Had the petitioner purchased the property and registered the same by way of a single deed, comma, the respondent authorities would not have got the opportunity to arrive at two different valuations for ascertaining the market value of the subject property. Stop paragraph. In the instant case, it is the self-same property purchased by the petitioner by way of two deeds of conveyance. Stop. The dates of purchase, however, are different.
This one is of 2005 and the one which has been completed registration 2007. The back portion is of 2007 and front is 2005.
The front portion of the property, which is currently being assessed, was
purchased earlier.
Purchased in the year 2005,
Lordship.
And the back portion of the property, which was purchased by the petitioner, was in the year 2007. Stop. Next. According to the West Bengal within bracket prevention of undervaluation of instruments bracket close rules, comma 2001, the manner in which the market value of a property is to be determined is mentioned. Stop paragraph. The best piece of evidence is the deed executed in respect of similar nature and area in the same locality. Similar nature and area of the property in the same locality or in a comparable locality. Stop paragraph. The appellate authority appears to have digressed itself and relied upon considerations which are secondarily admissible for ascertaining the market value of the property. Stop. Next. the authority ought to have relied upon the deed in respect of the self same property executed just 2 years after the property in respect of the subject writ petition was কি বললাম?
Upon the deed in respect of the subject property just 2 years after the property in respect of the subject writ petition.
Subject writ petition stuff next. In view of the above, the impugned order of the commissioner, Bird 1 division, dated 22nd of May 2023, is set aside. Stuff. The commissioner is directed to revisit the issue all over again in accordance with the Indian Stamp Act, 1899 and the regulation, 2021 mentioned to herein above. And in the light of the observation,
Regulation
past
2001.
Regulation 2001, ota 21 na, ota 2001.
But it's rules, my lord. It's not the regulations, rules.
Rules ই তো বললাম না, এটা রুলস 2001 উপরে বলে দিয়েছিলাম, ওইটাই সেম। আচ্ছা, and in the made by the court in the order dated 25th of April 2023 in WPA 20974 of 2022. Steps shall be taken in the matter at the earliest, page 107 আছে, at the earliest but positively within a period of 6 weeks from the date of communication of this order. The writ petition stands disposed of.
Lordship, only one indulgence, Lordship. The rule says that, Lordship, it has to give effect to the preceding years, not the retrospective effect, Lordship. Only that, if Lordship kindly records, because we can consider the valuation of 2025, because it has to be preceding years has to be considered, Lordship.
In that even valuation will come down further.
Lordship, in that even the valuation would go in the same valuation as 3 crore.
Next.
Sir, may I take back the, my lord, may I take
Yes,
back
yes,
my
book will be given back to you.
Wait.
In spite of our efforts, my lord, the reconciliation could not took place, my lord. And my lord, still now, my lord, the senior citizen is out of her home. And my lord, with the help of the local councillor, my lord, if it is so, then so the one attempt they have made with the GD entry that they have went. Yes.
Submitted that matter, settled down, and this is the view of his lordship that the daughter, married daughter, and mother. What will be done, my lord?
Fight between the married daughter and the mother.
Yes, kindly see page 30 and 31. I made the complaint prior to this application before the concerned police authority. I am, page 31 is the second paragraph, is the most important. Where, my lord, I am saying that, my lord, they are trying to oust me. Police did not take any steps. And I mean oust. Then, my lord, before the presiding officer, since the commissioner of police is the
Who is staying there now?
staying there by the my married daughter and her husband. With,
Show you. Let me see the report.
I think it has been submitted already.
Oh, is it there? 19th of November. Same report, দেখুন তো।
Yes, 19th of November. Yes, madam. It has been mentioned, my lord, that they are frequently, this Swanso, both of Swanso, my lord, being the respondent number 4 and 5 of the petition, during efforts of Swanso was visited and found premises was under lock and key. However, available local were examined and it has been learned that the said respondent has visited Swanso very often. None of the available local could be able to throw any light regarding the present whereabouts of the respondent number 4 and 5.
I disbelieve this report because, my lord, they are the influential, my lord. Yes.
Whose land is this?
This is my land. I am annexed, my lord, my property details, the deed.
Is the private respondent parties over here?
Yes.
Private respondent, is the private respondent represented by anybody?
No, my lord. Since beginning, no.
No.
No. They were intimated through local OC. Since they are not care to intimate, my lord. In terms of your lordship action. Let them come.
The petitioner, comma, a senior citizen, aged about 68 years, alleges that her married daughter and her son-in-law have forcefully thrown her out of her own house. Stop. Why are you here before this bench?
Because, my lord, kindly see the last representation, because the maintenance tribunal is the appropriate authority. I made an application before the concerned tribunal. They did not take any steps. If they would have taken steps, I would not have before your lordship. My lord, kindly see my representation dated, my lord, by page 32. As per the Act of 2007, my lord, the Commissioner of Police is under this Act is the competent authority.
He is the presiding officer of the maintenance tribunal.
Yes, my lord.
Achha,
I have exhausted all my alternative remedies.
Complaint lodged before the maintenance tribunal is not being responded to by the presiding officer. Stop. The petitioner is out of possession of her own house. Stop. Paragraph. None represents the private respondents. Stop. Peruse the report of the officer in charge, Jolabangal Police Station, signed on 19th November 2024.
Not by the presiding officer. Yes.
Stop.
Because he was based
It
upon
appears that
under statutory obligation.
a spot inspection was conducted.
Mother, I am disputing this report.
And efforts were made to communicate with the private respondents.
Wow.
But the subject premises was found under lock and key. None of the available persons from the locality could throw any light regarding the present whereabouts of the respondent numbers 4 and 5.
May I bring one indulgence, my lord?
Stop.
In response of my
The
complaint dated
report also
2022,
mentions that
inquiry is made in the year of 2021, after a year.
Respondents, private respondents, visited the house very often. Stop. Paragraph. There is nothing on record to suggest that the owner of the house has been directed by any order of court to be thrown out from her own house. Stop. Paragraph. There is no reason to believe that the petitioner has voluntarily left the house. Stop. Is the petitioner a widow?
My lord.
She is a widow.
Widow.
The
And my lord, my complaint dated 5/9/2023 was inquired after a year, after my lord filing this petition.
petitioner, being a widow lady, ought not to roam out even when she has a house of her own. Stop. Next. For ends of justice, the court is constrained to direct the officer in charge, Jorabagan Police Station, to break open the padlock of the house at 34B
VK Pal.
yes. ঠিকানাটা আছে ঠিক আছে and allow the petitioner to enter into and reside at the said house peacefully without any interference from from the private respondents or their men and agents. Stuff next. Steps shall be taken at the earliest, but positively within a period of 48 hours from today. Stuff. A compliance report shall be filed before this court on the adjourned date. List on 17th of February, next Monday.
I'm getting.
এটাকে ফেরত দিয়ে দিন, অন্যটা আছে। আচ্ছা, একটা লাইন লিখে দিন, the private respondents are restrained from obstructing the petitioner in residing at the said house without any valid order from any competent authority.
Yeah, 4-5.
Lordship, before the matter start of item number 12 and 13, for the respondent number 7, Ms. Osmita Chakraborty is appearing. She is suffering for high fever, Your Lordship. Only not this
12
week.
and 13?
Yes, Your Lordship. Only not this week. Because
But as far as 12 is concerned, my lord, I have instructions to withdraw the writ petition.
Then nothing remains in your writ petition. And 13?
13, Your
13, my lord, for the petitioner, my lord, this I cannot stand in the way.
Yes, Your Lordship, because she want to submit some certain documents.
Administrator.
Oh,
Lord,
administrator.
This pertains to, my lord, where my lord, the leakage of roof, my lord, your lordship directed, my lord, for repair of the roof by the administrator. There was a direction from the corporation, my lord, Procon, and
whatever. Now, since there is a request, but then you have got instructions not to proceed.
But I have written instructions.
Please give.
The Josh Sahib,
Acha, 12 number. Item 12. Learned advocate on record of the petitioner produces a written instruction from the petitioners disclosing their intention not to proceed with the writ petition any further. Step next. In view of such instruction, comma, the writ petition being 14869/2024 stands dismissed as not pressed. Stop. Item 13. On the prayer made on behalf of the learned advocate representing the respondent number 7.
Yes, Your Lordship.
Hearing of this matter stands adjourned till 24th of February 2025.
Lord,
In the meantime, is there any interim order?
Lord, interim order, your lordship passed a direction that the repairs will be carried out by the
Is it being
administrator.
carried out?
Nothing.
Nothing.
Nothing. On the contrary,
he is not posted with the fact. Your lordship knows, my lord, PNB account was not being allowed to be operated by the administrator. By the last order, your lordship directed that Punjab National Bank will allow the administrator, whom my lord, my learned friend senior is appearing, Osmita Chakraborty, to the administrator. That report should come before you.
Lord, that bank account, my instruction is there are 6 in total number of 6 accounts. 3 are meant for the maintenance purpose and the 3 for my lord, the PN.
17th করে দিন।
7. I'm great. Great.
জানাবাবু
17
এটা কিন্তু
junior would be here.
আপনি কাকে রিপ্রেজেন্ট করছেন?
আমি তো petitioner আমি petitioner তো
Yes, 14.
Want to be this side?
I am for the writ petitioner, my lord.
Yes.
My lord, in this particular matter, I am led by Advocate General, my lord. Lord,
For the petitioner, for the
for the
state.
state, my lord.
All right.
I am this side because I have filed
Yes,
application.
this is the reason.
I have filed an application which is on board, my lord.
All
For
right.
recalling of your lordship's order.
Lord, may I just summarize?
For recalling.
For modification of an order. Lord,
Yes.
I am the health minister of Jharkhand.
Oh, this is coming from the division bench's direction
Yes,
for.
it is that.
May I hand over the order of the division?
It chole.
Yes.
Milord, we have preferred an appeal against an order passed by your lordship, where Milord, your lordship was pleased to Milord direct release of cash which was seized on transit and Milord return of the passport of two persons who say that they are the members of the Jharkhand Legislative Assembly. Now, Milord, in gist, Milord, the sequence of events was that Milord, on NH 16, Milord, certain cash was recovered from a car. Based on that, Milord, a zero FIR was lodged in a police station in Jharkhand. And thereafter, Milord, it was transferred to West Bengal, and at Pachla police station, Milord, a case was registered. Now, thereafter, Milord, the accused moved 226 application before the learned Jharkhand High Court, challenging the zero FIR that was lodged over there. Now, the zero FIR and some other connected matters, Milord, they were quashed. And at the end of that judgment, it was written one sentence, consequently, the Pachla PS case number, etc. is also quashed. Milord, two things are different. Milord, as your lordship knows, Milord, now of course it is in the BNSS, but Milord, before the BNSS, Milord, the Supreme Court and High Court decision said that if an FIR is to be registered.
What happened to the Supreme Court?
Yes,
SLP?
then Milord, we went and challenged before the Supreme Court.
Hmm.
But before the
Notice
Supreme Court,
issued.
my learned friend's client appeared. Notice was issued. Several directions were given, extending the time to file their response. I'm not very sure whether they have filed it or not, but as per our last information, it has not been filed.
And it is pending.
And the matter is pending before the Supreme Court. This is one aspect of the matter. The second aspect of the matter is that your lordship has been pleased to note the consent of my counsel on the appearing on behalf of the state, that the state does not have any difficulty or objection in returning the cash and the passport, which, Milord, we are not contradicting, but what we are saying is that is contrary to what has been given in the report, which has been taken on record by your lordship, Milord, which I'll place. So, Milord, the consent, I'm not saying that the consent was not given or wrongly.
Because the consent was given, I distinctly remember,
I
and
don't
the
dispute that.
live
I don't dispute
recordings will also be there.
Yes, yes. I don't dispute that, but Milord, even if the consent is given, Milord, it is
That is contrary to the
record-
instruction forwarded.
instruction which has been taken on record by my lord. This is number two. The third aspect of the matter is, Milord, the return of the passport.
Hmm.
Now, the passport was deposited, Milord, in court because of a division bench direction. And therefore, if they want to get back the passport,
They should apply before the
apply
division bench.
before the division bench.
All right.
These are, Milord, my three fundamental limbs of argument. Now, Milord, if my learned friend wants to, Milord, address your lordship without affidavit, then it's one thing. I can address your lordship here and now.
But
Or
then the
else-
court is not ready to hear this issue without an affidavit. Since firstly, an issue is pending before the Supreme Court.
Yes.
Second, there is a division bench's order for
By the
establishment
division
of-
bench's order, Milord, I am protecting against the appeal from your lordship. But I was only praying, instead of embarrassing myself before the division bench, if your lordship may extend the division bench's interim order.
Where is that?
Yes. Where the order of the Honorable Division Bench, there a copy দাও।
ওটা annex করা নেই, আলাদা করে দিয়ে দিন, sir.
মামলাটার নাম কি রে?
The division bench's order is here before me. Which portion?
Please give me a moment, my lord. My iPad is giving problem.
Paragraph
Giving me-
14. আমারটা নিয়ে নিন।
Thank you. But we have said everything before the division bench. Where after recording this, after para 14, after we have dictated the
Yes.
above order, the learned
We remain with
state
the
submitted that the
special
Honorable Division Bench and
subject to
subsequently passed an order
consideration.
directing passport to be remained with the special court and subject to further.
All right,
orders of
may
the court.
require
Therefore, the direction
consideration.
issued by licensing to move these may also require reconsideration. না এটা তো না কোন জায়গাটা একটা
Where is the order of the division bench
Yes,
pursuant to
kindly
which
give me a moment.
CRM.
Yes. Please give me a moment. I'm a bit handicapped today. My
Is it not
device
annexed anywhere?
Yes.
Is it annexed to the application that you have filed? You should
No,
have.
acha, acha.
When you rely upon an order, you should have annexed it. Is the number CRM DB 2782 2022?
It's a MAT 140.
Matt?
Matt.
No, the division bench's order pursuant to which the passport was deposited.
Oh, that order, yes.
My lord, your lordship may kindly have a look to
That
my lord.
order is at page 42 of
No.
Can 1.
Please first take, my lord, page 173 of my application.
Yes.
This is 10th of November 2022.
Yes. 2782, yes.
Yes.
This
Now,
has been referred to in the division bench's order,
Right.
Chief.
please come to, my lord, page 175.
Yes.
In view of the aforesaid circumstances, we are of the opinion, interim bail granted to the petitioner may be confirmed subject to the following conditions. Please take II.
Passport, if any, deposited by the petitioners will remain with the said subject to further orders. Yes.
Yes.
This is a subsequent order.
Yes.
What was before your lordship was a previous order where interim bail was granted, and as a condition for interim bail, we had to deposit our passports. This subsequent order was not placed before your lordship. In fact, even in the division bench's order,
that is also my
Listen,
case.
I have made my mind clear to both of you so that you all get to know how to proceed. A matter is pending before the Supreme Court first. There is a division bench's order at the time of grant of bail for depositing the passports.
Yes.
And what is the other point that you raised just now?
Number one,
The
Supreme Court and the consent. Third is
consent.
the consent.
Consent was not proper.
But
there is an
the
instruction.
instructions also show that there was no opposition from the state for me getting the money back or my passport. I'll show the instructions also.
No, it doesn't
the report
matter.
which was taken.
Now it has been specifically objection has been raised that it cannot be given. So it's better you file affidavits.
I will
Let them
file an affidavit.
And,
I'm bowing down. I just have one request. Milord, I'm a serving health minister of a state. Milord, my passport today, it's well settled that a passport.
Listen, for getting your passport, you can approach before the court where the passport is seized.
Yes, that liberty your lordship had granted me. Pursuant to that liberty, my lord, there's an order passed that yes, the passport can be taken. But even then, my lord, because of my lord, now this confusion that has been created, that aspect has been held up. Your lordship may kindly clarify that the court will be at liberty to, my lord, allow me to take my passport. Because
why liberty to take passport?
My lord, because passport was deposited pursuant to me being granted bail.
Yes.
That bail was granted in August 2022.
17th August.
That is the order, my lord, which was placed before lordship and also before the division bench. Now the division bench holds here, in the said order, interim bail was granted and the matter was directed to appear. Learned advocate for the writ petitioner, that is me, does not have specific instruction as to whether any further order or direction has been issued in the bail application. Now, my lord, there is a further order wherein, my lord, the bail has been confirmed and I have to deposit my passport subject to further orders passed in the case. Now, the further order passed in the case is that the entire FR is quashed. So
that is pending before the Supreme Court.
But no stay has been granted.
I understand. I understand.
There's a prayer for stay and the prayer has been refused. In the SLP, there is a prayer for stay. That prayer has not been. So, my lord, today.
So you can approach before the court. Why here? Why before this bench? Before the court, which is holding the passport, you can make an application and you can.
Your lordship granted me that liberty and I've exercised that liberty. And an order also has been passed, but the passport hasn't been given. Your lordship will kindly.
That is a different thing. This the court cannot.
Your lordship may just kindly clarify that your lordship is not staying any or part of the order which pertains to the passport. Because as of today, there is no law which prohibits me from traveling. My lord, it's a fundamental right. I can travel wherever I want. Maneka Gandhi, passports case, my lord, Sauni's case.
If the order is set aside by the Honorable Supreme Court, then whatever conditions have been imposed, all will revise.
I will give whatever undertaking I have to, I'll give, my lord. Supreme Court may also set aside subject to certain riders. And unlikely, because it's been quashed on merit.
The state filed an appeal before the Supreme Court, isn't it?
Yes.
Why is the state not proceeding?
Yes, I'll be instructing them to.
Because see, these complications will arise.
These complications arise. These complications arise.
And when stay has been refused.
No, it is not refused as such. But still, there is no
If
stay.
there is a
There is
play
no
and
stay.
it's not granted,
But I don't accept that it has been refused. But there is no stay. That is also
so there is a prayer for stay, but there is no stay. That implies to a refusal.
Was the stay petition moved at all? Or it's only a formal prayer for stay?
There's a formal prayer. Please have a look to the Supreme Court's order, page 148. Please have a look at page 148. This is the first order of 14th of July, 2023.
Yes, issue notice, returnable.
Then kindly take the next order, which is 6th of October, 2023. This is at page 157. Now the respondent seek an adjournment. 4 weeks time is granted. Then page 158 is 22/1/2024 at page 158.
Yes.
The state
Again,
of Jharkhand,
they seek time to file their reply.
state of Jharkhand this time, my lord, also is directed to file the reply. Milord,
There is nothing recorded that formal prayer was made also.
May or may not be, my lord, it's not recorded.
Anyway, Ligunto. An application has been filed by the state for recalling / modifying the order dated 5th July 2024 in WPA 16180 of 2024. Step. By the said order, the writ petition stood disposed of by passing certain directions. Step. The state preferred an appeal against the order, and the matter is being reconsidered by this bench in compliance of the direction passed by the Honorable Division Bench. Compliance na in terms. Stuff paragraph. It has been brought to the notice of the court that the entire issue in question is pending consideration before the Honorable Supreme Court. Stop. Next. The order was the order of the court dated 5th July 2024 was passed upon consent being recorded. Consent of the learned advocate representing the state respondents being recorded. Stop. The instruction forwarded by the instructing officer did not mention about any consent to be recorded. Stop. It has also been pointed out that there was a direction passed by the Honorable Division Bench on 10th November 2022 in CRM within bracket DB number 2782 of 2022 within bracket CRAN 1 of 2022 at the time of grant of bail. Stop. A condition was imposed by the court that the passport, if any, shall be deposited by the petitioners before the trial court, and the same shall remain with the said court subject to further orders passed in the said case. Paragraph. Learned advocate representing the writ petitioner submits that the writ petitioner has applied before the learned trial court and has obtained a no objection order for return of the passport. Stop. Paragraph.
That's at page 179 of CAN 1. Second last paragraph.
The order dated 18th of July 2024 passed by the special court, passed by the judge of the special court, West Bengal, bracket open, MPs and MLAs, cases, bracket close, in special case number 24/2022 within bracket GR 4350/2022 in Pachla PS case number 276/2022 dated 31st of July 2022, wherein the
It's at the first page, page 179, second last paragraph. In compliance with the solemn order dated 5/7/24 passed by the Honorable High Court in WPA 16180, the prayer for return of
the
passport.
court was pleased to direct return of the passport in terms of the order passed by this bench on 5th July 2024. Stop paragraph. As it appears that the order dated 5th July 2024 is required to be recalled in the light of the facts that have been brought to the notice of the court. Accordingly, the order of the special court also requires reconsideration. Stop. Next. The instant writ petition will be decided after filing of affidavits by the respondents. Stop. The respondents are directed to file affidavit in opposition within a period of 6 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing upon completion of affidavits. Stop. Paragraph. It will be open for the writ petitioners to approach the Honorable Supreme Court in the pending petition for further relief in their favor.
My lord, insofar as the passport is concerned, is your lordship granting any directions?
The order of the special court is required to be revisited because the court passed order relying upon the 5th July's order. If 5th July goes, then subsequent order also has no consequence. So it has to be reheard. It will be open for the court.
But
If
is
any
your lordship's
application is
pleasure
made.
to, my lord, stay your lordship's order for some time?
I am recalling it.
Oh, recall.
The order is recalled.
Very good. Then and then. Very good. I'm grateful.
Grateful, my lord. Okay, go to the Supreme Court. There's a door open for you. You're not remedy.
15, my lord, I am for the petition.
Can dispose হয়ে গেল কিন্তু can disposed.
I am for the petition, my lord.
Yes.
State was to file the report, my lord. I am filing my exception, my lord. The petitioner is aggrieved by the installation of the VAT over his plot, my lord. For that, my lord, we have purchased the plot in the year 2021, my lord. Thereafter, my lord, they have started construction, my lord. We have made a case.
There is already a report by the Transmission Company Limited. What else do you want?
My lord, kindly look at the report, my lord. My lord, they are only saying that.
May I interrupt my understand? Just now the exception has been handed over to me. My lord, I have not gone through.
Let me hear just yes.
Always.
My lord, I have purchased the property in the year 2021. They have started their work in the year 2022, my lord. We have filed a 144 before the subdivisional court, my lord, magistrate, my lord. Thereafter, we have obtained an order of restraining the.
Tell me why do you want the shifting of this line?
My lord, or pay compensation according to the law. Fair.
Apply. There is a forum where you
My lord,
can
we have made a representation before them, my lord.
Where is it?
My lord. It's at page 53, my lord. Starting from page 53.
Who is the competent authority to decide upon this?
This is the हमारे तो ये तो
Director project.
yes
Director project has
Director
made
of-
party, my lord.
of project who is also a party to this.
Director of projects,
Respondent
let him consider. Please come. The petitioner is aggrieved by the inaction on the part of the respondent authorities in considering the representation filed for removal of the removal of the electric high tension line by the West Bengal State Electricity Transmission Company Limited, or alternatively to pay compensation.
Now, other party is there. They must be heard.
Who is the other party?
That is the
Highway Development
High-
Corporation Limited.
Highway Development Corporation Limited. Why?
Because of their request, it has been shifted.
Who is the party?
Highway Development.
Highway.
Yes, yes.
Highway is not a
And
party.
yes. The,
Highway is not a party over here, my lord.
Doesn't matter.
very well. The as it appears that the representation is pending consideration for a considerable period of time. Accordingly, without entering into the merit of the same at this stage, at this stage, the instant writ petition is disposed of by directing the director within bracket projects, West Bengal State Electricity Transmission Company Limited, being the respondent number 4 herein, to decide the representation in accordance with law, after giving reasonable opportunity of hearing to the petitioner and all other necessary parties,
Lordship.
and pass a reasoned order at the earliest, but positively within a period of 12 weeks from the date of communication of this order.
Within
Writ
12
petition stands disposed of.
12 weeks.
Exception to the report, exception of the petitioner to the report filed by the respondents be written with the records.
Lordship.
Next.
I'm for the respondent number 6, my lord, limited.
My lord, I am appearing for the petitioner, your lordship. I'm praying for a withdrawal on this matter, your lordship.
I can see that is recorded, but where is the written instruction? Why do you want withdrawal? Who are you? Are you the advocate on record?
I'm in the advocate on record, your lordship.
What is your name?
Shubham Das, your lordship.
You want withdrawal?
Withdrawal on
Why?
this matter. Because of the reason, your lordship, the client was not disclosed so many facts before filing this petition, your lordship.
Yes. Now he has come up with all these facts. Why will the writ petition not be dismissed with costs for wasting the court's time?
I apologize, your lordship.
Your apology will not do. What is your submission?
Not getting any.
I am for the respondent number 6, my lord, Mahindra and Mahindra Limited. There is no relief shot against me because I am for the petitioner purchased a car, and that model name is Mahindra and Mahindra Limited, and there is no work against us. There is no part against me. Why they are?
Why
filed-
Mahindra and Mahindra Limited?
Yes, lordship. Why they are filed this case? I also don't know.
Please come. The advocate on record of the petitioner submits that he has oral instruction to withdraw the writ petition, as the same has been filed with various incorrect facts. Stop paragraph. In view of such submission, the instant writ petition stands dismissed as not pressed. Do you want to file fresh writ petition?
No, your lordship.
You'll not file. It is recorded that you had made a prayer on the last occasion for filing fresh writ petition. You are getting the writ petition dismissed for incurable facts.
No,
Now,
I am instructed through my client, your lordship.
You do not want to file fresh petition. Very well. Dismissed. You will be debarred from filing any petition.
I'm I'm praying for liberty, Your Lordship.
Who is advising you? Are you taking help of anybody?
No, Your Lordship.
Then without taking help, how will you know what to do? You are causing prejudice to your client. Leave granted to the petitioner to file fresh writ petition upon proper and better particulars on the self same cause of action.
Lord, I am appealing for the petitioner.
I am for the pro forma respondent.
Petitioner of the BL and.
You are for the pro forma. Who is for the state?
I am for the state.
Yes, what is the matter?
My lord, what happened there when duty, they are performing his duty, my lord, as a my lord mutation case, it is my lord, they are under perform a quasi judicial proceeding when its record of rights has been my lord, a case has been my lord initiated against the all BLE LRO, my lord, when they are performing the quasi judicial proceeding in
Who
a
has
my lord,
initiated?
my lord, the aggrieved person. There is a provision that BLRO, my lord, there is
Yes.
any, my lord, order passed any BL and LRO, there is a appeal provision. Appeal provision 58, there is a 54 of the BL and LRO Act. My lord,
BL and LRO Act, there is no act.
there is a Land Reforms Act, West Bengal Land Reforms Act.
Land Reforms Act.
Yes, ma'am. My lord, they are, my lord, not filing any appeal. They filing a case, my lord, criminal case without any basis, my lord, of the BLN and LRO. Several criminal case, my lord, pending, which was, my lord, any, my lord, out of any, my lord, criminality is there. My lord, kindly go through my lord, representation before the authority itself, my lord, page 115.
Yes, 115, 30th of May 2024.
Yes.
Shubhashish Mukherjee while discharging was the petitioners are BLLROs.
Yes, my lord. Officer of the
petitioners are, I think, ADM and returning revenue officers.
no, they are the revenue RO and revenue officer.
Not Block London Land.
One is ADM according to their pleading, and two are revenue officers.
Two are revenue officers.
Steps have been taken against them.
The complaint has been registered, and according to the complaint, in Indian law, no one can be stopped from raising a complaint. Some person somewhere has lodged a complaint, and accordingly, FIRs have been drawn or not drawn. That's a separate matter altogether. But what they want in the writ petition is a blanket protection for them. We as a state, there are two sides of it. One is as an employer, because they are our employees. There is one side of it, and one is the investigating side. If a complaint comes to us, we'll have to register an FIR if required, if a cognizable offense is disclosed. My learned friend, having considered up to section 54 of the Land Reforms Act, will see that in section 58, well, I'm sorry, I stand corrected, my learned senior friend, at section 58, anything done in official capacity, that protection is already there. Number one. Number two, the erstwhile CRPC, now BNSS, has a protection for sanction.
Are you taking any steps?
These are individual complaints against three different persons. They want a blanket protection against any criminal action against them.
Are you taking any steps? Have you taken any steps?
Then police report has to be called for. I have not called for police
Apart from the police, is there any step that are being taken?
No.
No,
these are not disciplinary proceedings at all. My learned friend may be absolute. I say maybe because I am also investigating agency. Had I been speaking only for the employer, I would have said that my learned friend is absolutely correct. But question is, can a person, any person who is an applicant before a BLRO or an applicant before a DLRO, can be restricted from filing a complaint?
No, when they are
I don't, given it to the state,
any
state
order
will
passed
like.
in a quasi judicial proceeding, anybody can file a criminal case against the judge.
The state will be happiest if
the
there is
criminal
no.
court. Why are you before the writ court?
No, my lord,
the association has been made a pro forma respondent in this.
Yes.
My lord, the association is absolutely supporting the petitioners herein. But in addition to the same, if I may clarify before your lordship certain things. My lord, in the event, a prayer is made for correction of records. My lord, there are segments in the website or e-portals where the BLRO and other revenue officers, whoever are entrusted with the action of correcting a record, they are provided with a page, web page, with certain previously fixed averments over there. They cannot even modify that averment. Now, due to non-availability of such modification, subsequently some other aggrieved party that this correction should not have been made comes with the defense that this particular averment ought not have been there. There had to be a different averment that these things had happened.
No, I understand.
The grievance actually, the BLRO, what the BLROs and revenue officers are facing, my lord, they are unable to discharge their duty while in a proceeding in a quasi-judicial character. They are unable to discharge.
No, but then the law protects you.
Yes, my lord. Now, section, right, they have challenged. Two of them have been quashed also.
So you can
but,
get these quashed
my lord, every revenue officer at the behest of
suppose a
yes.
complainant
Yes.
with a complaint
yes.
goes before the police station.
Right.
What will the police do? Police will take
in
steps.
the event a cognizable offense is disclosed, police
They will
has
take
to
steps.
has to register an FIR.
And if it is not done, the aggrieved party will come before
Certainly,
you.
my lord. But
and say that
our
state is
grievance,
protecting its employees.
right, my lord. What our prayer is,
yes.
Like
What is the
revenue
prayer?
officer, that is a framing of a regulation or rules, which will put us in a framework which will at least give us some protection, not section 58.
That you can always apply. Your employer is there. You can.
They have
always
applied.
go.
That was not considered. They have applied.
Which one?
The representation.
115.
Yes.
You want this to be considered?
Absolutely, my lord.
Will that serve your purpose?
No, consideration in the event that is rejected, we can come up with come up against the stand of the state.
This oral prayer, kindly see this. Oral prayer by the pro forma respondent is that make a policy. Now,
is there any?
May I speak for 2 minutes?
Yes, please.
With the leave of
Please.
both of my friends, my lord, they want a policy to be framed. Now, policy has to be read with the prayer. Kindly see the prayer. Prayer last
don't
three lines.
Look at the prayers. That is the reason I wanted to know what exactly the petitioner wants.
They want the state to frame a policy granting absolute immunity with regard to.
Yes, followed.
State will be happiest to do it, but question is whether the law permits us to do it.
They can.
That is the question that I asked.
They can at least.
Section 50.
Give us the authority to modify.
May I read section 58 for everyone's convenience?
My lord, before initiation any criminal proceeding, must be inquiry.
If a preliminary inquiry is permissible, police will do it. But how can they do it?
Permissible, but they are not doing it.
They are not doing it. 150.
It is permissible.
And case has been started against.
Lalita Kumar squarely says that.
When my
Not that for invoking
quasi-judicial
Lalita Kumari, you have to go before a different bench.
Under Article 226, while dealing with this scenario, your lordship, your ladyship can also intervene. And my lord,
if you want a framework to be in place,
yes,
then it will be a different authority.
That is the prayer before the writ court.
If that is a prayer, then it has to be restricted to the Land Reforms Commissioner and the Secretary Land and Land Reforms.
My lord.
Can frame a policy.
Yes.
In consultation with the judicial department. Otherwise, policy cannot be framed.
Absolutely.
My lord, may I read section 58 for everyone's convenience?
For what purpose?
Because what they want is already incorporated in the statute.
Well, it is not an adversarial litigation.
I know. That is what I am trying to explain to my learned friends, that this cannot be done. Kindly, my lord, here's
This
section
cannot
58.
be done. Intimate them that this cannot be done. Reject the prayer.
Let it be rejected. Non-statutory representation. My lord, kindly hears out section 58 once. But I'm sorry, I'm not having a copy. My lord, kindly bear with me for 2
Read
minutes.
out.
That no suit, prosecution, or other legal proceedings shall lie against any person for anything which is done in good faith, done or intended to be done in pursuance of this act, or any rules framed thereunder. No suit or other legal proceedings shall lie against the state government, so and so. So subsection 1 of 58 already protects them.
despite 58, they are facing criminal charges because they have done some work in their official capacity. This is what they are troubled with.
But
Or,
someone,
or else,
but
your
someone
lordship,
leaving the office
or
goes
else-
to the
or-
police station and registers
You
a
cannot
complaint.
stop. You
We
cannot stop
them.
But then at
There
the
is
same
appellate
time,
authority also.
you are prosecuting. You are prosecuting. These people
Then
are
the safeguard,
threatened.
safeguard
My
is
lord,
under the
then your
PSS,
lordship-
my lord, because no
If you
government
say
servant
you
can
will
be
not take
proceeded.
steps against them, they will
And
be
my
very
lord,
happy.
another thing.
That cannot be said at all. My lord, kindly presume the situation.
I can
That
understand.
state, my lord, I repeating, my lord, state will be the happiest if no FIR is registered against any of
My
its
lord, if the
employees.
state is happy,
But
will be
question, your
happiest,
lordship has seen in various matters
your lordship,
the other side of this.
Yes.
your lordship kindly
This
then
is what
clarify the
at the very
situation.
beginning I said, if somebody aggrieved
And now,
party, if his complaint
The
is not
provision of sanction
registered,
is there under the CRPC and now
yes,
BNSS.
That is in
If
respect
it,
to
right.
any public servant.
any public
My
servant,
lord,
so any,
then my
beyond
lord,
that CRPC, whether only for revenue officers and BLRO,
because they are
another
performing
provision of sanction
quasi-judicial,
can be given. my lord.
because they are performing quasi-judicial duty. And my lord, while performing
I
quasi-judicial
now,
duty,
it,
your
it is
lordship
appearing
can,
to me that is a writ petition by the pro forma respondent in the name of the three
because
petitioners.
this is the association, they have done the right thing. I'm supporting them. And my lord,
very well.
It is also
and my lord,
supporting them.
and my lord, one more thing, your lordship may kindly clarify them
What?
that Judges Protection Act will be extended to them while they are
Why?
dealing with quasi-judicial proceeding.
No, Judges
Section 3.
Protection Act, it has been
Yes,
described to
because
whom it will
that
be restricted.
distinction they are initiating
Defined.
complaints.
It is
The
defined.
magistrates will be prosecuted for
Please come.
passing a simple order.
The petitioner number 1 claims to be the Blockland and Land Reforms Officer. Now, claims to be the Assistant Director, comma, Additional District Magistrate and District Land and Land Reforms Officer, Purva Bardhaman. And the petitioner numbers 2 and 3 are working as the Revenue Officer in the district of Uttar Dinajpur and Malda, respectively. Stop. While performing certain official duties, comma, the petitioners have been sought to be prosecuted under the provisions of the IPC. Stop. Criminal case has been registered against them, which is pending before the learned Metropolitan Magistrate at Calcutta.
So there are two.
And also before the
One is Pandua, one is Malda.
and also before the Pandua police station and Malda police station. So 3 cases, Calcutta, Malda and Pandua. Stop. Achha. The petitioners seek immunity from criminal actions, from criminal prosecution while discharging their official duties. Stop. Paragraph. A representation was made before the respondent authorities, including the judicial department.
Only by the petitioner
and
number
the
1. Seeking his own immunity.
Land authority. Respondent number 1. Petition number 1.
His immunity.
Petitioner number 1. Supriya Pandey. Subhashish Mukherjee.
Kindly sees the heading, subject at 115 and the prayer at 118. He only wants a blanket immunity for himself. That is the policy he is seeking.
No, but then representation was made by all 3. All 3 made representations. Ah, you bolam representation bolam. As well as the police. Stop. The same has not been responded to. Learned Counsel representing the state respondent submits that section 58 of the West Bengal Land Reforms Act, 1955 already prescribes certain protection to the officers while performing their official duties. Stop. it has been contended that that there cannot be any order restraining lodging of complaints against the officers of the state. Step. Whether the said officers against whom complaints are filed will be prosecuted or not will depend upon the inquiry to be conducted by the police.
And my lord, provision for sanction under 218 of BNSS.
There is already, but then this act was under the was under the IPC. Why are you bringing in the BNS? You have to say the corresponding section of the IPC.
My lord, this is corresponding provision I'm giving, my lord. Corresponding provision of CRPC is, my lord.
Yes, IPC, it has the
My lord,
sections.
218 of the new act is 197 of the old act.
There is already provision. There is already provision for obtaining sanction
against against prosecution of judges and public servants.
Against prosecution of public servants under
section 97 of CRPC.
197
Of the CRPC?
97
Yes.
197 of the criminal procedure code. Stop paragraph. Upon hearing the submission made on behalf of all the parties, it appears that the petitioners are public servants who are facing certain problem while performing their official duties.
Well, not only official duties, it's a quasi-judicial proceeding. They are performing his quasi-judicial proceeding.
Yes, but this is official.
Rising out of official duties.
This is official duty. The petitioners have brought the same to the knowledge of the superior authorities. The authorities ought to take into consideration the representation that has been filed. In view of the above, the instant writ petition is disposed of by directing the Land Reforms Commissioner and the Additional Chief Secretary, Land and Land Reform and Refugee Relief and Rehabilitation Department to consider the representation filed by the petitioners in accordance with the prevailing rules and thereafter take necessary consequential steps if required. Stop paragraph. It will be the aforesaid respondent is directed to afford an opportunity of hearing to the petitioners to ascertain the difficulties that they are facing so that some alternate way or relief may be provided to them. Stop paragraph. The aforesaid respondent shall take steps in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioners immediately thereafter. Stop. The learned advocate for the petitioners is directed to forward a copy of the representation of the petitioners to the aforesaid respondent at the time of communicating the order of the court. Disposed.
Wait.
Well, the next item.
Yes.
আমি থাকলে তোর মামলা হবে তো কর।
On the last occasion, there was a direction, file an affidavit in reply that served upon them. This is the affidavit in reply. But the point was, my point was, in absence of a specific clause, to look after, a maintenance tribunal had heard, in cancelling the deed of gift. I have judgments, to rely on.
So this has to be heard.
My lord, this has to be heard.
Affidavit in reply filed by the petitioner to the opposition filed by the respondent number 7 is taken on record. Stop. The matter is required to be heard. Stop. List the same for hearing in the
Kindly,
monthly combined list of March
my lord, would not, my lord,
2020
under the heading, my lord.
2025.
My lord, kindly, my lord, not under the heading.
Where to keep it?
My lord, as a motion, my lord, kindly would take it up.
Hearing as motion after affidavits, exchange of affidavits.
Kindly take it, otherwise, my lord.
Otherwise, I'll start taking up these matters on motion stages. It is up to the bar.
My lord.
No. But it will appear in the monthly list of March.
Yes.
But the point of maintainability has been kept open.
Very well. If it is open, it is open. The court is not interfering.
But item number 21, my lord.
Yes.
This is a tender matter, my lord.
Yes.
On last occasion, Friday, it was adjourned, my lord. The state prayed for.
Very well. Please wait. Item 19. Let me see once.
Lord, during this matter, Lord, I appear for the
Sports
Authority of India, but I am extremely sorry I could not be here last occasion. My junior took note what was submitted by the RSI. The learned advocate appearing for the petitioner. Now, Lord, thing is this, Lord, I, at the behest, Lord, I will take the point of maintainability of the writ petition before dealing with the judgment cited before your lordship. Now, Lord, for the reason, Lord.
Now it is already 4:31.
Right.
So the matter will remain
Only
in the
one
list.
thing that I may point out, only one thing, because Lord, I needed customs to be implemented as the party.
Yes.
Because customs exemption was required. Now, Lord, we have given the certificate. They did not have it. But the alternative remedy is there. They could have preferred appeal. That they did not do.
Yes, I'll hear you on the next day. The matter will remain there in the list. Call 21s. 2020.
And for the private respondent.
Is the petitioner here?
Mr. Somi Ganguly is appearing.
I am for the distribution company.
Not here. Very well. It's past 4:30. Call 21.
21, my lord. I am appearing for the petitioner, my lord. Here, my lord, we have challenged a notice inviting tender on certain conditions, my lord. There was an order passed. I'm being led.
May it be taken up on Wednesday at a fixed time.
Fixed time will be difficult, but Wednesday, yes. Fixing time will be a bit difficult. It will remain in the list.
Wednesday, we have to keep kept at the top or something.
Yes, yes. It is already there at the top of the urgent motion bundle. All the top matters are disposed of. So it will be there.
Let it be in the supplementary list on Wednesday, my lord.
Matters from the combined list will be there in the supplementary list. Were you mentioning something?
At the fag end of the day, I should not disturb your lordship.
Well, yeah.
But even after thought of the particular attitude, it doesn't put it in that matter. And now they want to get to the issue.
So what will this court do?
Today is almost what tomorrow I let me something. We can something be given.
No, but then police in action, this bench does not have determination. Police in action, this bench does not have determination. This bench is not taking up police in action matters.
Lordship earlier said that partial modification of the determination is could not be done. But if anything, your lordship whatever it.
No. Thing is, if this bench does not have the determination, then how can the court hear? Police in action is not in this bench. You have to try out before the bench having determination.